apologies for absence. There is a sheet going around. I don't think there's any apologies to make, is there, Tricia? Thank you. Agenda item 2, members to declare any interest in the matters related to be discussed at the meeting today. I wish to declare a non-pecuniary interest in all matters related to today's hearing. Any other declaration of interest, please? Agenda item 3, to confirm the minutes of the meeting which was held on 1st December as a true record. Correct? All agreed? Thank you. And agenda item 4 is the consideration of a complaint reference MC/03/0517. I'll then go on to Chair's announcements. Please note that members of the public and press are now allowed by law to film on audio, record, take photographs, blog or tweet at this meeting. I would ask at this point if anyone is intending to film the meeting. No. And I would ask anyone who is recording to avoid any disruption of the meeting and to avoid filming members of the public. If you do film members of the public, there is a potential for civil action against you by anyone who has not given their permission to be filmed. We are not expecting a fire drill, so in the event of the fire alarm sounding, please leave the building as quickly as possible. The Government Service Officer will direct you to the appropriate exit and assembly point. And finally, please switch off mobile phones or turn them into silent mode. Thank you. And now may I first ask everyone to introduce themselves, starting from our independent person.
James Cornwell, Council, independent advisor, legal advisor to the subcommittee.
Councillor Jeff Lewis, and I'll be chairing the proceedings today.
Councillor Sue Crompton, Standards Committee.
Councillor Steve, member of the Standards Committee.
Councillor Barbara Price.
Brian Rickers, Union full-time official representing.
Councillor Ian Jones.
Ronnie Dennis, barrister, legal advisor to the investigating officer.
And I'm Maria Price, I was the investigating officer.
Today's hearing is not a court of law. The Standards Subcommittee are today meeting to determine as to whether Councillor Jones did or did not break the Code of Conduct, namely the Code. The committee here today will act and take decisions impartially, fairly and on merit, using the best evidence and without discrimination or bias. And there is a procedure we have to follow. I'll now hand over to the legal advisor to the subcommittee today to make a presentation.
Thank you. There are, as subcommittee understand it, a couple of preliminary applications that are to be made on Councillor Jones's behalf. Before that, I just want to briefly outline the procedure that it's proposed be conducted. In relation to the applications, I suggest that what happens is that Councillor Jones's representative, Mr. Rickers, makes his submissions in relation to those applications. Mr. Dennis then has an opportunity to respond to those applications, with a brief opportunity for Mr. Rickers then to respond to the submissions of Mr. Dennis. Now, the applications, as I understand it, relate essentially to a submission that either all or some of the members of the subcommittee have a conflict of interest and should recuse themselves, and two, in any event there should be an adjournment, but I'm sure Mr. Rickers can explain in due course. Once there have been submissions in relation to the applications, then and any questions from the subcommittee in relation to those submissions, then the subcommittee should seek the views of the independent person, Mr. Tomkinson, and I will provide legal advice in relation to the applications, and at the end of that will give both Mr. Rickers and Mr. Dennis the opportunity to make any observations as to the correctness or otherwise of my legal advice. The subcommittee will then adjourn to consider the applications. What then happens will obviously depend on the decision that the subcommittee reaches, but it will come back at some point and announce its decision on the applications. Obviously, if the applications result in an adjournment, then that will be announced, and that will be the end of the proceedings for today. Conversely, if the applications are refused, then we will need to proceed with the substantive hearing. The order for that is set out in the arrangements made by the Council for the investigation and consideration of complaints in relation to members' conduct. Those have been supplemented by some Chair's directions, which I think were agreed, at least in relation to the broad form, by Mr. Jones, Councillor Jones's previous solicitors. But the basic procedure will be this: if we get to this point of having substantive consideration of the complaint, Mr. Dennis will outline the investigating officer's case as to why there has been a failure to comply with the Code of Conduct. As I understand it, Mr. Dennis is not calling any witnesses. There will then be an opportunity for Councillor Jones to respond and set out why it is said that there has not been a failure to comply with the Code. So the order for that would be any submissions from Mr. Rickers, calling of any evidence on behalf of Councillor Jones. If evidence is called, Mr. Dennis would then have a chance to cross-examine the witness. There would then be a brief opportunity for re-examination on Mr. Councillor Jones's behalf, arising purely out of any cross-examination by Mr. Dennis. The subcommittee and independent person and legal advisor would also have an opportunity to ask questions of any witness. At the end of the evidence, there would then be closing submissions. Councillor Jones, on Councillor Jones's behalf, responding to the complaint, and then Mr. Dennis setting out why the complaint should be upheld, with a brief opportunity for any reply submissions from Councillor Jones or from Mr. Rickers. And then there would be legal. Subcommittee would then turn to its independent person to give his views, and finally turn to me to provide legal advice to the committee. And then at that point, the committee would adjourn to consider in private whether or not there had been a failure to comply with the Code, at which point the committee would then return, give its decision on that matter. If it was found that there was no failure to comply, then that would be the end of the matter. If there was found to have been a failure to comply, then Councillor Jones would have the opportunity to say what, if any, action the subcommittee should take. Mr. Dennis would have the opportunity to make any submissions on sanction on behalf of the investigating officer, with the opportunity for short reply submissions on behalf of Mr Jones, and then the subcommittee would then adjourn again to consider the question of sanction and come back and announce its result, this decision. That is the broad procedure that will be conducted today. So I think, unless anyone's got any questions in relation to what I've just said, it probably falls to Mr Rickers to make his submissions on the applications he wants to make.
Thank you, Mr Cornwall. Yes, the outline of your proposals would seem reasonable, except for one point, that the committee is then asked to rule on its own conflicts that it has. I note that Councillor Lewis has advised that he has a non-pecuniary interest, but there are other interests that we have raised with regard to other members of the panel. So whilst normally it would seem reasonable that the panel make a decision on the submission that I'm going to read out in a few seconds, it seems unreasonable that the same panel make the same decision on whether they are conflicted or not.
Well, I think my advice to the subcommittee would have to be that there really isn't any alternative. They are the body that is charged with considering this complaint, and it will fall to them to decide whether or not they can properly proceed. That is standardly the position in relation to courts and tribunals. If an allegation is made that a judge or tribunal member is subject to a conflict of interest, it's ultimately up to that person to take a view as to whether or not that is correct. I'm afraid there's no other way of dealing with the matter. I don't know whether Mr Dennis has any observations on that.
No, I agree with those views. As you say, it's completely ordinary practice in judicial proceedings for a judge to take a view on whether they ought to recuse themselves because of an allegation of conflict of interest, and there's no other practical alternative in these circumstances.
Thank you. I've noted the comments made, but there is an alternative, and it's not for me to explain to the council what panel should be here and what panel should be sitting in judgment. The panel was formed, and at the first hearing I made it quite clear that there were material conflicts of interest. We have now made those conflicts of interest known to the local authority, and also that there are options for this local authority to convene another committee who is not conflicted. This is against the natural realms of justice, and I would hazard to say, as I come from Wednesbury, that it's against the cited set precedents of Wednesbury reasonableness, that it cannot be reasonably accepted that a panel, who I will clearly show are conflicted, can then sit in judgment and make decisions on whether they believe they are conflicted, and then to proceed with this case. If you wish, I will read out the submission that I've made asking for an adjournment with matters associated to those issues and others that have surfaced over the last 24 hours.
Mr Cornwell, do you want to come back on that, please?
I think Councillor Jones can proceed with his submissions.
Carry on, Councillor Jones.
Thank you, Chair. The request is for an adjournment for 14 days. We again formally request adjournment of the hearing today, as we have requested to you previously on a number of occasions. We will list the reasons below again now. Our client, myself, for the avoidance of any doubt, denies explicitly the allegations made against him and wishes to participate in any fair and impartial hearing. 1. Late provision of documents. I do have a copy, so Mr. Cornwall, if you require it, I will give you a copy, so your shorthand can be accurate. 1. Late provision of documents. The previous hearing was adjourned for various reasons, but one of the allegations made by our client, myself, was that the monitoring officer had said this case was document light. I have the documents in front of me, and you can judge for yourself whether the documents are light. To find that the bundles contained hundreds of pages with further documents provided on the day. The committee allowed an adjournment to allow for legal representation for our client and for bundles to be read and analysed and legal opinion on its contents being sought and advised.
Mr. Chairman, I'm finding it extremely difficult to follow this. I think it would be a matter of courtesy if Councillor Jones was to make that document that he's reading from available to us. And could I, because otherwise I'm going to find it very difficult to follow what is a fairly complex argument. I wonder, Chair, if you might allow an adjournment for a few minutes to allow copies to be made available to us.
I do have copies, and again, it's perfectly acceptable to give them out to you now.
Adjournment, please.
But I'm happy to have an adjournment for 15 minutes while and you digest what's been said.
Adjournment, please. Thank you. Thank you, Councillor Jones. It took longer than the subcommittee anticipated. But nevertheless, I'll now hand you over to Mr. James Cornwell for the legal advice on this, please.
I think it's I think it's a matter for Councillor Jones to continue with his submission first.
Yeah, thank you. Thank you. I'm sorry.
We have read the written statement.
Sorry for the interruption. I think I got to item 1, late provision of documents. The previous hearing was adjourned for various reasons, but one of the allegations made by our client was that the monitoring officer had said that this case was document light. To find that the bundles contained hundreds of pages with further documents provided on the day. That was at the last hearing. The committee allowed an adjournment to allow for legal representation for our client and for the bundles to read and analyse and legal opinion on its content being sought and advised. It is with astonishing concern that a further bundle of 216 pages was provided to our client's representatives, which was through 6 emails apparently sent at 8:42 p.m. on 22nd of January and opened by his representative on returning to work the next day, the 23rd of, and that should be January, not February, sorry. This being less than 1 working day from this hearing date, a further email was received on the 23rd with other documents. We informed Mr Tour that this was totally unacceptable and prejudiced our ability to read, digest and seek legal opinion on what was provided by Mr Tour. We wrote to Mr Tour about this late disclosure, but received what can only say be a dismissive reply that said the documents included our and previous correspondence and replies mainly. This was not completely true, as the majority of the documents provided were regarding the important schemes of delegations of officers and directly related to the legal arguments that would have been relevant to this case. We cannot understand why the monitoring officer has only now provided our client with these documents. We ask that time is given so that these documents can be read, analysed and legal opinion provided on their comment. Any fair-minded person would see that this late disclosure was unreasonable and unfair, and we cannot understand why, considering the previous difficulties surrounding this hearing, that this situation should arise again in this manner. Request for documents. We have continually requested documents and statements that the local authority has in its possession. As we have over a number of weeks, you have responded slowly and in negative in most part. You have questioned the legitimacy of those requests, which the hearing panel will deal with, and restricting matters to the narrow points in question. You are somehow trying to resist the legitimate defence that our client wishes to pursue.
Sorry, Councillor Jones, when you say you, who do you mean?
The monitoring officer, sorry. Namely, that there has been a political witch hunt culminating in the alleged direct actions of intimidation, harassment, sexual harassment and stalking, which also emanated these allegations and then investigations. These matters have been reported to the police by several individuals, and we believe to you as the monitoring officer. The direct links between the current serious allegations received by the authority and the allegations against our client cannot be divorced. This complaint is all too evident and derived from the WhatsApp messages between senior individuals of this council, and your attempt to restrict the defence to a narrow point of the allegation is seemingly a decision oblivious to the serious complaints that you have received, and again that's the monitoring officer, and in itself is against natural justice. The intransigence of the monitoring officer with regard to legitimate requests for documents, including statements and transcripts, that is in the possession of the council, but all have been refused. A request for a document that was provided to the Hussein panel members, and I note it is the same panel members, and referred to in that hearing by a panel member when asking questions of a witness who also seemed to have the document, which was in the public hearing. But again, this was refused, and the monitoring officer said he will be treating this request as a freedom of information request under the Act. 2. Monitoring officer's communication. It is perverse that the monitoring officer communicated with our client and not his representative yesterday on the 23rd of January, informing our client of his code of conduct obligations and requiring him to be mindful of what he and his representatives say or not say at this hearing, with a further threat of a code of conduct breaches, and seems to try and to restrict what he or his representative can say or do, and is clearly against natural justice and impedes a fair hearing, and again demonstrates the lengths at which the administration is going to stop the truth behind these allegations being made public. And again, I do apologise for some of the typos. It was only finished at 2 o'clock this morning. 3. Conflicts of interest. Our client has identified clear and prejudicial conflicts of interest of panel members, and these have been provided to the monitoring officer, who informs us that the panel will address these requests after legal advice from the legal advisor to the panel. It would seem that the panel will decide if they think they have conflicts of interest in this matter, which seems perverse. And I do note that Councillor Lewis has said he has a non-pecuniary interest in these matters, where other panel members haven't. Objections to the panel. At the previous adjourned meeting, our client made reference to conflicts of interest of committee members, and to this end we list our concerns below regarding members of the panel. The Standards Committee and the Audit Committee members are appointed by the Labour Group and from the leader's recommendation, and as such the leader and the group have allegedly manipulated what should be an independent process, with the executive of the council having undue influence on committee appointments. The complaint to the police and the council involves members who would have this conflicted position. To demonstrate this further, a number of experienced councillors have applied for positions on these committees but have been refused. It is widely reported that there is a split in the Labour group, and has been reported in local newspapers and social media, with a significant number of Labour councillors being excluded from statutory committees. It has been suggested in High Court documents that this was the influence, the quasi-judicial role of these committees. A judge also made comment of the political interference within the council. To remedy these perceived conflicts, the opportunity now arises to make improvements, as there are now at least five independent councillors who could serve as independent members on these committees, and I don't mean as the independent person, Mr. Tompkinson, but as independent council appointments on these committees, if impartiality and transparency are the aim of the council, and could be appointed quickly so as not to further delay the hearing. We will object formally to all panel members in this matter, as they have been infected by comments and statements made by representatives of the council and witnesses in the Hussein hearing. Please note it's the same panel as those who were adjudicating in the Hussein hearing, which gives them a clear biased view of our client, and as such they cannot be unaffected. Members heard uncontested evidence without cross-examination, including some assertions which were blatantly wrong and as such are conflicted. Additionally, 3 members were present at the full council meeting on the 29th of November 2011, when they endorsed the decision to sell this plot of land by sealed bids, and they didn't raise any objection to the decision of the Asset Management and Land Development Committee of the 27th of October 2011, not to sell the plot by auction, but via sealed bids, the very points in question. And as such, the party and as such are party to the decision-making process and cannot now be considered impartial in this matter and are conflicted. There are clear conflicts of interest on the committee in matters that they have voted for at full council, that are directly or indirectly being asked to adjudicate upon the same matters, which clearly is a direct conflict of interest and perverse in law and against the rules of natural justice. It is perverse in law that you now consider that these members are able to be impartial in this matter, and we would cite the precedents of the Wednesbury reasonableness case in this matter. We also have individual objections to the panel who have been involved in adverse decisions against our client in the Labour group, and I do apologise for making these public, but we did try not to, which we are still outstanding and are in the appeal stage, and as such they are not impartial and are conflicted, and as such their impartiality is highly questionable and challengeable. In addition, matters that show a clear prejudicial conflict of interest to at least 3 of the current panel members of the committee. We will list them separately. 1. First is our client's intention to show that there has been collusion amongst members and officers to bring false allegations against our client, which would need to be developed and would include members of this committee who are cabinet members and appointees of the leader of the council and Labour group. They include group officers, which, as I've said, 3 of the proposed committee have clear conflicts of interest. 2. Second, our client has clear conflicts of interest with 2 of the committee who are Labour group officers, one being the chair of the Labour group, Councillor Jeff Lewis, who was appointed on the leader's recommendation and was the other who is Labour Group Secretary, Councillor Steve Trow, and who again was appointed on the leader's recommendation, and who both previously presided over a disputed disciplinary process that saw our client wrongly suspended from the Sandwell Labour Group, which is still unresolved and awaiting appeal with the Labour Party. Clearly, this is a severe conflict of interest. On the 5th of March 2015, a group of West Bromwich East councillors attended a private meeting addressed by MP Tom Watson regarding associated allegations to our client. This group then decided to try and pass motions at that evening's ruling Labour group meetings. Councillor Lewis presided over these 2 meetings of the group that evening, allowing prejudicial comments to be made by his fellow ward member and employee of Tom Watson, Councillor Simon Hackett. Councillor Lewis allowed discussion regarding our client's voluntary resignation from his position on the Cabinet and group. Councillor Lewis's role in these meetings and subsequent actions in the group show that he clearly has animosity towards our client, and as such his jurisdiction in these matters shows he is conflicted. Third, Councillor Shackleton, as a committee member, has shown animosity towards him because she was a head teacher who lost her job because of his decision to close her school, which she vigorously objected to, clearly a conflict of interest. Our client should be entitled to a fair hearing presided over by an impartial committee, which clearly these committee members are not, and they are unable to fairly demonstrate that they are impartial, and as such we would ask you to replace them. It is clear that no fair-minded individual would consider that these panel members are impartial in these matters, and as such should be replaced. Excuse me. 4. Witnesses. Councillor Jones wished to call witnesses, as he has identified, that the allegations are politically motivated and to show an abuse of process. He has informed the monitoring officer as to enable enough time for them to be available for this hearing. The cross-examination of these witnesses will also take some time, and we have an effect on the length of scope, and will affect the length and scope of the hearing. For the avoidance of any doubt, we list below those witnesses we have requested be made available for cross-examination. Jan Britton, Chief Executive. Councillor Ealing, Leader. Councillor Marshall, former Cabinet Member. Councillor Piper, Audit Committee Member. Councillor Giron, Audit Committee Member. Councillor Priest, Audit Committee Member. Philip Tart, Deputy Monitoring Officer. Mike Sullivan, former Interim Monitoring Officer. Maria Price, Legal Solicitor. David Willits, former Property Service Manager. Kerry Jones, Property Officer. Mitchell Spencer, Property Officer. Matt Lynch, Property Officer. Peter Farrow, Audit Service Manager. Audit Investigating Officers, names not known but are known to the local authority. Darren Carter, 151 Officer. The Monitoring Officer sent yesterday to myself and not the legal representatives, and this is a most salient point, has specifically said in respect of the Member Code of Conduct, Part 11, 1.8, you must not intimidate or attempt to intimidate any person who is likely to be 1, a complainant, 2, a witness, or involved in the administration of any investigation or proceedings in relation to an allegation that a member, including yourself, has failed to comply with his or her authority's code of conduct. That was sent yesterday afternoon, I believe, for me to digest. I haven't responded to Mr. Tour. I passed it on quite rightly to my legal representatives, because there are references where it actually says that I am responsible for what my legal representatives say, and that the breach of the codes will rely on me controlling what my legal representatives say. That to me is not natural justice, and it is horrendous. We have been mindful of this and now have requested those individuals for cross-examination so that natural justice can apply and that a fair hearing can be achieved. In the full knowledge of how the allegation was originally made and investigated, and what material was discarded during the investigation as being relevant and what's not. A meeting at Albury Council House between the Monitoring Officer, Mr. Tour, and Deputy Monitoring Officer, Mr. Tart. We have replicated the email to Mr. Tour below, sent on the 23rd. Excuse me. It has come to our attention that a meeting took place between you, that's Mr. Tour, the Chief Executive, and the Ethics Standards Subcommittee this morning in a room in Albury Council House. Please advise: 1. What was the purpose of the meeting? 2. What minutes were taken? 3. What contributions in the briefing did each individual make? 4. When was the individuals notified of the meeting? 5. Was the independent present or invited? That is a most important point. And he wasn't. 6. Was the independent legal advisor notified or invited. Again, a very important point. This is a very worrying turn of events, and the claims made that there has been collusion in these matters in the impartial arrangements required and that there should be transparency and honesty in all dealings regarding these matters. We have received a response to these questions, but those responses from Mr. Tour seem to conflict with the information that we have received. The worrying attribute to this meeting is that it included a witness or witnesses that we wish to cross-examine at the hearing, which was known to the monitoring officer at the time of this meeting, I'm assured. Another worrying aspect of this meeting and briefing was that the independent person was not present or invited to this meeting, something that is strange and throws doubt upon the motives of those who arranged the meeting. We are told that the committee legal advisor knew of the meeting being arranged. You may want to confirm or deny that. But we are not sure from the monitoring officer's reply whether he was asked if the independent person should have been invited so as to maintain transparency and honesty of the briefing. We're nearly there. It is clear that no fair-minded individual looking at this meeting would consider that this was an appropriate briefing in the presence of a witness or witnesses. We again request an adjournment on the points listed above so that a fair hearing can be provided and that natural justice can be done. Thank you.
Thank you, Councillor Jones. Mr. Dennis, will you please respond to that, please?
Thank you, Chair. Before I start, I'll just hand up three authorities to which I'll refer during my submissions, as it were. So the first of those is Hussain and Sandwell Metropolitan Borough Council. You've got one copy of that because of its length, and then you've got two copies of each of Gillies and Condren. And as I say, I'll explain why I say those are relevant in the course of my response to Councillor Jones's applications. I'd like to respond by just going through his written submission and making a few short points in relation to each of the points he makes. The first is that there have been further documents provided recently. That is, in fact, a bundle of correspondence between the parties, so there can be no possible prejudice to Councillor Jones from having had that yesterday, the day before, or even this morning. It's correspondence that he's seen because he's party to it. The only caveat to that is that there is one document in that bundle which is not correspondence, that is the scheme of delegation. Again, there's no prejudice to Councillor Jones. He's had plenty of time to digest that. Indeed, I only read it myself last night. And I can tell him, if it assists, that the only relevant pages, indeed the only pages to which I intend to refer the committee, are 78, which is the cover page, and 97, which is the relevant page for the purposes of the officer involved in these allegations. So there's 2 pages there for him to digest, and he has had plenty of time to digest those since he received the documents. If he hasn't, then he can look at those now. So that's the first point. The second point he makes is that he's requested documents, and here he makes an allegation that he makes a number of times in his written submission. This is his second page, the third paragraph. He says, "You are somehow trying to resist the legitimate defence that he wishes to pursue in these matters, namely that there's been a political witch hunt, etc." Well, there are 2 points here. The first is that that isn't a defence to the allegations against him. It's for this committee, under the Localism Act and under the Council's arrangements, to determine whether he's guilty of a breach of the Code of Conduct. That's all this committee is asked to do. These aren't judicial review proceedings. How the allegation came to be made is irrelevant for those purposes. You have evidence before you, and it's for you to determine on the basis of that evidence, and having heard from Councillor Jones, whether he has breached the code. So that's the first point, that it is not a defence to the allegation against him to say that there's a bad motive for bringing the allegation. Now, of course, we say that the allegation has been made perfectly properly. It arose out of a report made by the Audit Committee that you'll have seen. But as I say, that's not really an issue for the committee today. The only issue for the committee today is, on the basis of the evidence it reads and hears, has Councillor Jones breached the code? And the second point I'd like to make in response to that is by reference to Mr. Justice Green's judgment in Hussein, which is the first authority I'd handed up, and no doubt you'll all be able to have a look at that during your adjournment, but I'll read to you the relevant passages in any event. You may be aware these are judicial review proceedings that were brought by Councillor Hussein, challenging the fairness and propriety of the Council's investigation into standards allegations against him. Those judicial review proceedings were dismissed, and there's just a few paragraphs in Mr. Green's judgment that I'd like to take you to, because his Lordship did in fact consider similar arguments raised by Councillor Hussein in those proceedings. As we'll see, in those proceedings, Councillor Hussein also said that the allegations against him were politically motivated, and essentially Mr. Justice Green said that doesn't matter. All that matters for the committee is that it properly determines the allegations that have been made. So if I can just start by taking you to paragraph 10, Chair, and I'll read out what the judgment records there. So paragraph 10 of Mr. Justice Green's judgment in Hussein, he said there, at about this time, elections to appoint a new leader of the council occurred. Several members indicated that they would stand for election. This included a member who was the subject of the investigation, Councillor Jones. He was referred to in a number of places during those proceedings. It is argued, by reference to contemporaneous press coverage, that certain Labour candidates, in particular Councillor Ealing, used the press to promote their candidate for leader. The ongoing investigations became a political issue, with Councillor Ealing, who was standing against Councillor Jones, pressing for publication of the solicitor's report and the opinion and continuation of the investigation. The submission is now made that this was to undermine the position of Councillor Jones, and that the decision by the council to continue with the investigation and to publish the solicitor's report and the opinion was politically motivated. So there's a lot there you don't need to concern yourselves with today. The key point is that in those proceedings, Mr. Justice Green was faced with a similar allegation to the one you have here, which is that all the allegations are politically motivated. And you can see what the judge said about that at paragraph 28, which again I'll read to you. He said there, I agree generally with the position adopted by Mr. Gowdy QC for the council, that the allegations are serious and that there is a pressing public interest in those allegations being thoroughly and fairly tested and adjudicated upon. I also agree that the mere fact that the issues have acquired a political significance is not a reason for the council as a body to succumb to political pressure. On the contrary, it must act independently and objectively throughout. So as I've already said, we don't accept that these matters have taken on any political significance, but even if they had, that isn't the issue for you today. The only question for you today is there a breach of the code? And it is important for you to be mindful of Mr. Justice Green's guidance, which is that that is the only issue for you, that you mustn't succumb to political pressure, and there's no reason why you should. And finally, on Mr. Justice Green's judgment, paragraph 175, he went so far as to say, I accept, on the basis of the evidence before the court, that there could well have occurred a significant amount of political game playing at the time of these decisions, that is, the decision to refer matters in respect of Councillor Hussein for investigation. However, this serves to reinforce the importance in officers of the council acting with impartiality. They must take their decisions without regard to political considerations and on objective grounds. So that observation applies equally to you today. Whatever Councillor Jones may say about political pressure, it's for you to reach decisions on objective grounds on the basis of the evidence, and there's no reason why you can't do that. The only other point I'll make in response to this section of Councillor Jones' submission is that there are no further relevant documents that relate to the allegations. He's repeatedly said he wants to see other documents. There are no other relevant documents. On the top of his page 3, he refers to a conversation that he had, or says that he had with the monitoring officer, when the monitoring officer, he says, seemed to try to restrict what he or his representative could say. It seems that Councillor Jones there objects to being told that he must comply with the Members' Code of Conduct. Of course he must comply with the Members' Code of Conduct. If that restricts what he says, then so be it. It's incumbent on him to comply with the Members' Code of Conduct. Subject to that, of course, he can say whatever he likes, and subject to questions of relevance, which I may need to come on to. The next point that Councillor Jones makes relates to conflicts of interest. It's here that I'd just like to refer briefly to the two other authorities I handed up. Those provide you with some guidance on the legal test to be applied when you're considering questions like this. So the first is Gillies, and it's really paragraph 17 of that judgment. So this is a judgment of Lord Hope. He says the critical issue is whether the fair-minded and informed observer would conclude, having considered the facts, that there was a real possibility of bias, essentially. So the only question for you, which you must all consider yourselves, is whether a fair-minded and informed observer would conclude, having considered any of the matters that Councillor Jones raises, that there was a real possibility that you are biased in considering this complaint. Towards the end of that paragraph, Lord Hope provides some further guidance. This is at G. He says, it is to be assumed that the observer is neither complacent nor unduly sensitive or suspicious when he examines the facts that he can look at. It is to be assumed, too, that he is able to distinguish between what is relevant and what is irrelevant, and that he is able, when exercising his judgment, to decide what weight should be given to the facts that are relevant. One of the points I'll come on to make is that many of the objections that Councillor Jones makes are completely irrelevant to the question of whether you can properly and fairly consider the allegations against him. There's then further guidance in paragraph 38. This is the judgment of Baroness Hale, and she sets out there the appropriate test, again by reference to Porter and McGill, paragraph 38, where Lord Hope said that the court, in this case you yourselves, must first ascertain all the circumstances which have a bearing on the suggestion that you are biased. It must then ask whether those circumstances would lead a fair-minded and informed observer to conclude that there was a real possibility that the tribunal was biased. So there's a two-stage process for you. First, to determine the facts on which these allegations are made, and then to consider whether they would lead a fair-minded and informed observer to conclude that there's a real possibility of bias on the part of any of you. And then finally, just one paragraph from the Court of Appeal's judgment in Condren, and that's at 53. So 53, you'll see there, in the context of allegations of apparent bias against members of courts or tribunals, weight has been placed on the judicial oath of office and the fact that professional judges are trained to judge and to judge objectively and dispassionately. Then goes on to say, whilst the position of members of a planning committee, even at the level of the Assembly, is of course very different from that of judicial office holders, the fact that they have received relevant training and have agreed to be bound by a code of conduct is a consideration to which some weight can properly be attached when determining an issue of apparent bias. And I draw your attention to that because, of course, the same observation applies equally to all of you. You've all had training on how to conduct these procedures, and you've all undertaken to comply with the code of conduct, and that is something that would lead a fair-minded and informed observer to believe that you are capable of carrying out your role impartially. So that's the legal framework, if you like. And now returning to Councillor Jones' submissions, the first point he appears to make is that the Standards Committee has been appointed by the Labour Group and from the leader's recommendation. That cannot possibly give rise to an appearance of bias on the part of any of you. Taken without more, no informed observer would conclude that merely because of how you were appointed, you are biased. over the page, he says that you've been infected by comments and statements made during the Hussein hearing. He doesn't provide any specifics there of any particular statements. There's two reasons why that's not the case. First, that nothing, as far as I can recall, certainly having also attended that hearing, was said about this allegation, the only allegation you need to determine today. And certainly you weren't invited to make any findings in respect of Councillor Jones, so you're not biased merely as a result of having sat on that hearing. In other words, in legal terms, no reasonable, fair-minded observer would conclude that you are biased merely because you sat through that hearing. The next point is that it's claimed that some of you were present at a full council meeting in November 2011 which related to the same plot of land. I don't know whether that's true or not, but even if it were true, it's not alleged that you were party to the only decision that's relevant for today's purposes. That is the decision to remove the land from a sale by auction in February 2011. There's then a number of general allegations. It's somewhat difficult for me to respond to those because it's not clear to me who they're being made against. It's for you, of course, to consider in your own minds whether there's any merit in the allegation that you've all been, or that some of you have been involved in some sort of conspiracy. Of course, Councillor Jones hasn't advanced any evidence for that. There's then reference in particular to the Chair, Councillor Lewis and Councillor Troe, and their involvement in previous disciplinary processes. Again, there are no specifics provided there, so it's somewhat difficult for me to address you on those, but that fact alone, again, would not lead a reasonable and informed observer to conclude that there was a possibility that you might be biased in considering these, I assume, different allegations against Councillor Jones. Indeed, he doesn't say that those were the same allegations. There's then reference to Councillor Lewis presiding over a Labour group meeting when prejudicial comments were made. Again, I don't know whether that's true. Even if it were, it's not the sort of thing that would lead a reasonable informed observer to believe that any of you could be biased. The allegation in respect of Councillor Shackleton, I don't know whether that's true. Even if it were, again, the allegation that she was the head teacher who lost her job because of Councillor Jones' decision to close her school, even if true, that is not the sort of thing that would lead a reasonable and fair-minded observer to believe that someone who's had training in how to conduct standards hearings and undertaken to comply with a code of conduct might not approach their duties properly. There's then the issue of additional witnesses. Now, Councillor Jones has had ample opportunity to call witnesses, to produce witness statements, and I'd just like to take you to a few of the letters in the correspondence bundle to demonstrate that. The first is at page 1, so at the very front of the correspondence bundle. You see here a letter of 13 November 2017 from Mr. Torr, the monitoring officer. The penultimate paragraph, it's to Ben Henry, re Councillor Jones's standards report. It attaches a copy of Miss Price's investigation report. The penultimate paragraph says, to adequately prepare for the hearing, I have attached proposed directions for the parties for your agreement. Over the page you see those proposed directions. So this is page 2. Point 4. If Councillor Jones or the investigating officer intend to rely on any evidence from a witness who has not yet given a written statement in respect of the allegations against Councillor Jones, they must provide the other party with a copy of that witness evidence in the form of a written statement. And the deadline for that to be done was the 20th of November 2017, as you see in the column on the right. Over the page to page 3, you see Miss Price's email of 20th November to Ben Henry, Councillor Jones' representative at the time. It says, in line with the directions for the hearing of this matter, I confirm that I do not intend to call any witnesses, nor do I have any further documents to add. As such, I propose that the bundle to be used at the hearing is that which has already been provided to you in its current format. I propose that the only addition is your letter setting out Councillor Jones' comments on the report and the directions for the hearing, which can be included at the back of the bundle and numbered accordingly. Please can you confirm that you are content with this approach, and I will send you an amended index. We then see Mr. Henry's reply, 20th November, the same day. He says, "Hi Maria, I note that below and do not disagree with your approach." So no suggestion then that he intended to call any other witnesses or produce any other witness statements. The next letter to which I'd like to refer you is at the page 11, an email at page 11. This is from Mr. Tor again, 5th January 2018. Roughly halfway down the page, you see a paragraph that begins on the 13th November 2017. Mr. Tor says there, on 13 November 17, I wrote to the solicitors for Councillor Jones and attached a set of proposed directions with timelines, which were subsequently agreed by the chair of the Standards Committee, copy attached. This approach, as outlined in the directions, was also agreed with by solicitors for Councillor Jones. He then says, I have attached a revised set of directions in light of your comments concerning potential witnesses that you may wish to call. In this regard, please see the attached Standards Subcommittee reasons in relation to the adjourned hearing. In particular, I draw your attention to the final paragraph concerning the relevance of matters raised by Councillor Jones at the 1st December hearing and any potential witnesses he may wish to call as a result. Councillor Jones' responses to the allegations to date, both in his interview and via his former solicitors, do not appear to raise issues that any witness could usefully address apart from Councillor Jones himself and the then leader of the council, who has of course passed away. We then see at 13 the revised directions. And there you see the same paragraph 4. If Councillor Jones or the IO intend to rely on evidence, they should produce a written statement. The revised deadline there is the 12th of January. So time has already been extended once for Councillor Jones to produce any written statements. Of course, this hearing's already been postponed once. He's still not produced any written statements from any other witnesses, and for that reason alone there should be no further delay to this hearing. But there's also another equally important point, which is that, as we've seen from that email, or as was said in that email, there are no witnesses who could provide relevant evidence, and this goes back to the point I made earlier, that it isn't for you to determine the allegations that Councillor Jones now makes about political motivation, etc. All that it's for you to determine is whether the allegations against him are true and whether he has breached the Members' Code of Conduct. There's then reference to a meeting at the Council House involving the Monitoring Officer and Deputy Monitoring Officer and Mr. Tor. It's alleged there that the Chief Executive was also present at that meeting. That's not the case. Indeed, the Chief Executive wasn't here. He was on leave. There's then a series of questions to which the Council has responded, and you see that response at page 31I in the correspondence bundle. So this email actually begins at 31G. You see there from Mr. Tour to Mr. Rickers, Councillor Jones' current trade union representative. Thank you for your email. I've responded to your questions below in blue. And if you then read through to 31I, the question is asked, what was the purpose of this meeting? Towards the end of the second paragraph there, the subcommittee members were advised that they needed to consider all the evidence and issues raised carefully and reach an informed decision on the representations made and evidence presented. That's the substance of the advice. The beginning of that paragraph, the subcommittee members were advised that there were preliminary points likely to be raised, so that was the purpose of the meeting, and of course you will know the purpose of the meeting to which you were invited and which you attended. So there's nothing in that, again, that would lead a reasonable, fair-minded observer to conclude that there's any possibility that any of you is or would be biased in considering the allegations against Councillor Jones. Thank you, Chair. I have nothing else to add.
Thank you for those comments, Mr. Dennis. Much appreciated. I'll now turn to Mr. James Cornwell, the legal advisor to the panel.
Thank you. Mr. Cornwell, it's this one. Okay.
Sorry, just to be... What we need to happen next is Councillor Jones will have an opportunity to reply. Mr. Wilkinson will then provide any views that he has, and I will provide legal advice. But before that, various assertions have been made on Councillor Jones's behalf as to the actions of various members of this subcommittee. And it seems to me that it would be appropriate for them to put on public record what their position is in relation to those. And perhaps if a way to deal with that is for me to take them to the points that particularly seem to need addressing. There are particular allegations about Councillor Trow, Councillor Lewis and Councillor Shackleton. So if I could start with Councillor Trow in relation to the allegation about his involvement in referring a disciplinary matter involving Councillor Jones to the Labour Party. Could you please explain, put on public record your understanding what the factual position is in relation to that?
Yes, thank you, Mr. Cornwell. The facts of that matter relate and are required to comply with the Labour Party's disciplinary procedures and rules that are applied across the country for the operation of disciplinary matters, or the hearing of disciplinary matters by Labour groups. It is a requirement under those rules that group officers, including the chair and the secretary of the group, take no part whatsoever in deciding whether there should be any disciplinary hearing. They have absolutely no role in making that decision. It is entirely a matter for the chief whip to decide, and then the obligation is to arrange a hearing, and at that hearing all standing orders of the Labour group are suspended, and there is only one item. That item is for the chief whip to present his or her report and recommendation, and then for the group, by a secret ballot, to decide whether they approve that recommendation. There is no role for me as secretary of the group, or for Councillor Lewis as the chair of the group, in determining and certainly not referring a matter for investigation or for consideration as a disciplinary matter. That would be in direct contravention of the Labour Party's rules.
While we're with Trow, there's also an allegation in relation to, I think, particularly cabinet members. It's alleged that cabinet members were involved in the complaints, the complaint against Councillor Jones being investigated and then referred to this committee. Have you had any involvement in this complaint being investigated and then referred to this committee, apart from in your role as a member of this subcommittee?
I can give absolute assurance I've had no role whatsoever. There's been no discussion within Cabinet about referral of this matter. There's no decision that I have been party to. My only role and the only conversations I have had have been the proper ones in terms of briefings with officers on this matter once it had been referred to the Standards Committee, and in my role entirely as a Standards Committee member and not as a Cabinet member.
Chair.
You'll have the opportunity to comment.
Just
You will have your opportunity to comment, Councillor Jones.
Just for brevity, you've made a wrong interpretation. I did not put that point of the members as
Councillor Jones, can you please be patient and wait as the our legal advisor said and come back a bit later?
But if he's going to ask each and every one of you
He'll
a
ask
wrong
me,
question,
yes, he's correct. He's made that statement. The legal advisor made that statement. He's called Mr. Trow, and I take it now he'll probably be calling me. Thank you.
which, again, the allegation has not been put.
Right, what is the allegation then, Councillor Jones?
There is no allegation regarding collusion amongst the group officers at Cabinet.
Right, so just to be clear, you are not alleging that any member of this subcommittee was involved in any collusion in relation to your the complaint being pursued against you. Is that correct?
The allegations are listed in the document that I've given.
Well, you have said that I've misunderstood the allegation, so I think it's very important that you're very clear. Are you making an allegation against any members of this subcommittee as to whether they have colluded in the complaint being pursued against you?
You specifically mentioned the Cabinet and Councillor Trow's role as a Cabinet member. That is not being alleged. It is in roles and conflicts that they have in their group positions.
I'm not sure that's a clear answer to the question. Are you making an assertion that any of the members of this subcommittee are involved in collusion?
There has been conflicts of interest with regards to the matters of group officers.
Councillor Jones, with respect, that's not true. I mean, there is written statements from us.
Next is Councillor Lewis. There's the allegation that you're involved as chair of the Labour group. Could you briefly explain your understanding of the facts in relation to that?
Yes, thank you, Mr. Cornwell. On the night in question, when we deliberated on that meeting, I was there as chair in capacity. This meeting itself was conducted by a regional office, Labour Party, from Terry Duffy House. We had officers there who conducted that business. I didn't. I just sat there at that particular meeting just to observe that the meeting was conducted correctly.
And there's an allegation in relation to a March the 5th, 2015 meeting. Got any comments in relation to that allegation, Councillor Lewis?
Only the fact that, as I've said, and I'll repeat again, that I sat there in my capacity as chairing that Labour group meeting, and an officer and officers from the Labour Party were present, and they conducted the secret ballot. Thank you.
There's then, in relation to Councillor Shackleton, that you have shown animosity to Councillor Jones on the basis that you were, it's alleged that you lost your job as head teacher as a result of a decision he made. Have you got any comments in relation to the factual position there?
Thank you. This goes back probably about 2002 to 2003, maybe, when it was policy to amalgamate schools. On your recommendation, Councillor Jones, a decision was made by full council to close the school. I accepted this decision then and moved on to a job at the university, as I didn't want to apply for the new substantive post. Since joining the council, I may add that I have been a member of the cabinet working alongside Councillor Jones. There has never been any animosity between us in our roles on the council. I'm therefore impartial in this hearing and will be fair-minded based on the evidence before us. Thank you.
I think that's all of the specific allegations in relation to individual members of the council. I think the next step is for Councillor Jones to reply to Mr. Dennis's submissions and anything that's arisen subsequently.
Councillor Jones, you now got the opportunity to respond to Dennis's statement. Thank you.
Thank you, Mr. Chairman. I note the reply of the panel. I hope that it's been taped, because there are some matters which would need further clarification on points that have been raised by the panel members. And I'll say no more than that. The response from Mr. Dennis is predictable, and quotes of court of law. I was told at the start of this meeting this was not a court of law, quasi-judicial committee, and the authority has a duty to provide fairness, impartiality and natural justice. I have presented the submission and will await your decision on that decision. We now ask for an adjournment so that you can make your deliberations. Thank you.
I want to now bring Mr. Tompkinson, the independent member, in to make a statement, please. Mr. Tompkinson, with you, please. Thank you.
Thank you, Chair. I am not ready to make a statement of my advice to the subcommittee, because there are numerous matters in the submission that has been made by Councillor Jones this morning that I would like to question, and I would ask you, Chairman, if you would be prepared to indulge me.
Yes, carry on, Mr. Tompkinson.
Thank you, Chair. Councillor Jones, I wonder if I could take you through a number of points in your submission and ask you for a comment. Firstly, you made on the first page, on approximately paragraph 3 below the heading of late provision of documents. May I say that I have spent time looking through all of the documents, so you can take it that I'm aware generally of the content. You made an assertion that the majority of the documents provided were regarding the important schemes of delegation. I wonder if you could, in terms of the overall number of documents that you take objection to, could you give me the approximate percentage of the documents that are your or your representatives' emails, the approximate percentage that are of the monitoring officer, and the percentage that relate to the scheme of delegation?
Thank you, Mr. Tomlinson. The 220 pages, a third are correspondence that we have wrote or received, which is legitimate. The other 2/3 are schemes of delegation with acts of responsibilities and acts of law attributed to them, and 2/3 of those would be part of that 2/3 bundle, and those were received less than 24 hours to this meeting, and we've received some more. And I note Mr. Dennis's 120 pages, which is just produced as well.
So, approximately a third of the documents you self-generated? Yeah, okay, fine, thank you. Could I ask you please, because I do not understand the reference on page 2 to WhatsApp messages, can you please tell me what relevance that has to a decision that the panel might make on deferral, adjournment?
Thank you, Mr. Tomlinson. The WhatsApp 1945 WhatsApp messages, and the witness we were or are going to call, but legal advice will be given as a matter of course, that the 1945 WhatsApp messages over 12 months were between the witness that we wish to call, Mr. Julian Saunders, who is a local blogger and community activist. The WhatsApp messages are in the possession of the police, and the content of those which we have provided to this panel and do not appear on the public documents, along with Mr. Saunders' written statement, are not in the bundles, do not appear on the internet, and they are very grave messages which the police and the CPS are at this moment looking at, as other authorities are as well, which has an implication for further questions regarding those matters. Very serious and grave allegations which have been raised in Parliament, on the House floor and other forums.
Thank you. That was very interesting, but actually not helpful to me, Councillor Jones. Could you please tell me what relevance they have to the matters that we're considering today? I'm advised that that's the last question I will answer, and then we will leave. But the relevance is that the documents are quite specific and show that senior members of this council have been involved in harassment, intimidation, bullying and sexual harassment claims. Those are specific and have been published and are in the possession of the council, in possession of the monitoring officer and in possession of the police, and refer to other members of my family and other individuals with regard to that. And if proven, it will show that very senior members of this council have been involved in what could only be described as disgraceful witch hunt for political purposes. And some of those were referenced in the High Court cases that Mr. Dennis had mentioned. I'm now being told on legal advice that I will not make any more further comments, and I ask that you to look at the submissions that have been made and come to a decision. And I'm sorry, I presented myself at many interviews and at many investigations regarding the last 12 months, and I always will. But on legal advice, I'm being told that we would conclude our deliberations and leave the meeting. And thank you for hearing us. Thank you.
That's your prerogative, Councillor Jones.
Sorry, I think, Bolt, the committee hasn't yet considered your adjournment application. The committee hasn't yet considered your adjournment application. You do understand that they may decide to proceed with the hearing, and you will not be here to present your case. Do you do understand that? You fully understand that?
Sorry, Chair, I ought to make another thing clear as well, which is that I intend to make an objection to the admission of Mr. Saunders' statement and to you hearing from him. I raise that now before Councillor Jones has left the room in case he wants to object to that application.
I think you could say that we would object because
You're welcome.
Right.
I'm rather, how can I put it, dislocated by the incident that's just happened, Chair. I can give advice, but I would prefer to take 15 minutes just to compose my thoughts.
Get Mr Tompkinson back in now, please, with statement. With you, Mr Tompkinson, please.
Thank you, Mr Chairman. Hopefully that you can hear me. I apologise if the length of this advice to you might seem rather long, but it is phrased carefully to try to anticipate everything that has happened today. Basically, my advice to you is whether I consider there should be an adjournment. First, I'd like to remind the hearing subcommittee of the advice that I gave to them before they determined there should be an adjournment on the 1st of December 2017. That was in the interests of openness and transparency, and in the interests of Councillor Jones, and because of the cost involved and the continuing damage potentially to the good name of the Council, there was a public interest in having these matters resolved. I noted that the matter has been in the public domain since January 2017. I noted that nothing that has happened after February or March 2011 will have changed the facts of the matter before you, and I would therefore question the relevance of any witness testimony that Councillor Jones would bring before you. However, I accepted that Councillor Jones was not represented at the hearing, and I therefore considered that if Councillor Jones was prepared to commit to participate fully in a hearing within a reasonable time frame, then I would support an adjournment on that basis. The grounds on which a further adjournment is sought are contained in a number of emails that have been presented to me as part of a correspondence bundle. Additionally, this morning, Councillor Jones has submitted a statement that seeks a 14-day adjournment based on a number of issues. I have read his statement, but only due to his decision to withdraw and limited opportunity to review numerous points that I'm uncertain about. My considerations are, firstly, has Councillor Jones or his representatives put forward any new substantive reasons why there should be an adjournment beyond those that he put forward in applying successfully for an adjournment on the 1st of December? First, the large number of documents being received late. I was able to ascertain from him that a large percentage related to one background document, and the remainder represented exchanges of correspondence that he was a party to. Secondly, a meeting held on the 24th of January at which the subcommittee was briefed. Councillor Jones has given me no compelling reason for believing that this is evidence of a detriment to his case. In the correspondence bundle, Mr Rickers has asserted that a one-day hearing is insufficient for bringing this hearing to a conclusion. I do not see this as a valid reason for an adjournment, as it will be for the hearing subcommittee to determine whether the conclusion is achieved in the outlined timescale, and the earlier a start is made on resolving this case, the earlier a conclusion one way or another will be reached. I'd also like to comment on the assertions in the correspondence bundle by Mr Ricker, in which he says the way the allegation was first made and how it was received and subsequently investigated by all those concerned is a legitimate avenue to explore through cross-examination, including the investigating audit officers and the involvement of the monitoring officers and other officers throughout this process is part of the complaint, and the assessments will be a legitimate avenue for our client to challenge, and as such we intend to call witnesses, including officers, and you need, that's addressed to the monitoring officer, and you need to ensure that they are available for this hearing. I note that Mr Rickers only yesterday submitted a list of names that he wanted to cross-examine as witnesses, and I think it unrealistic for that request to be made just over 48 hours prior to the commencement of the hearing. And further, the submission this morning did not convince me of the relevance of those witnesses to the events of February 2011. I note that Mr Rickers has repeatedly asked for unspecified documentation in correspondence with the monitoring officer, but I cannot form a view of the relevance of that without a clear understanding of which document he is seeking, and it was my intention to ask the question of Councillor Jones and Mr Rickers this morning as to more clarity around that issue and the relevance of those documents to the events of February 2011. But Councillor Jones has decided to deny me the opportunity of questioning him. So, in conclusion, my view is that no substantive reasons have been put forward for a further adjournment. My second area is it likely that there will be any other material coming forward following an adjournment that will materially alter the outcome of the hearing? I note that Mr. Ricker submitted a list of names that he wanted to cross-examine as witnesses, and I think it very unfortunate that Councillor Jones has not taken the initiative to request them to produce a written submission in time for this hearing, and therefore I must conclude that they will add little to my understanding of the events of February 2011. My view is that I still hold to my previous advice that I think it unlikely that anyone on that list of witnesses that's supplied by Mr. Rickers can add materially to the hearing subcommittee's knowledge of what took place in February 2011. Again, I conclude that nothing will change were there to be a further adjournment. My third area is it in the public interest for there to be an adjournment? The public interest, I conclude, is in having this matter resolved in the shortest time possible and with the maximum opportunity for both sides to produce evidence to the hearing subcommittee. And in that respect, I note that Councillor Jones has not complied with a number of directions, for example, providing a list of witnesses by the 12th of January or agreeing the statement of facts by the 19th of January, which demonstrates to me an unwillingness to engage with this process, thus potentially delaying the outcome against the public interest. And I would suggest that his withdrawal this morning is further evidence of his unwillingness to engage with the process. My view is that the issues about considering an adjournment I considered on 1st of December have not materially changed, except that Councillor Jones now has representation, the absence of which was material in the advice I gave to the hearing subcommittee on 1st of December. And because of the passage of time since then, the need to have this hearing concluded can only have increased. I note further that Councillor Jones gave the hearing subcommittee a clear commitment on that day that he would participate in a hearing arranged within a 3 to 4 week period. And as we're now over 7 weeks after that date, I personally feel it wrong that Councillor Jones should now seek to avoid that public commitment which he made freely and openly. I consider that a further delay in this matter being heard is not in the interest of the public, who will have noted that the subcommittee already have agreed to one adjournment and that Councillor Jones made, in my view, a clear commitment to participate in a rearranged hearing. I do not think members of the public generally will consider a further adjournment to be appropriate. As a result of all that, my advice to the subcommittee is that an adjournment is not appropriate. Thank you, Mr. Chairman.
And thank you for those comments, Mr. Dickinson. I think now it's coming towards... Do you want to come back, please? Coming towards past 12, and from that I think we shall adjourn for lunch, because I'm led to believe that lunch is arranged for 12:30.
So before we adjourn, I will give my advice on the procedural matters. Taking them in turn, there are essentially two issues. One is in relation to conflict of interest, and the other is any other outstanding matters in relation to adjournment. So starting first in relation to conflict of interest, Councillor Jones submits that some or all of the subcommittee have a conflict of interest and should recuse themselves. It may well follow that if that application is granted, that the hearing would then have to be adjourned, the quorum for the committee being 3. Legally, the committee needs to bear in mind two definitions. The first is of actual bias, and that is where a tribunal unfairly regards with either favour or disfavour a party's case. And then apparent bias, which Mr. Dennis has already referred to in his submissions. The classic statement of that is in the House of Lords decision in Porter and McGill. Whether in all the circumstances would the fair-minded and informed observer conclude that there was a real possibility that the tribunal was biased. The fair-minded and informed observer will be aware of all the facts that will be available to the public and is someone who is neither unduly credulous nor unduly sceptical or cynical. It will be for the committee members to consider whether, applying those tests, it would be inappropriate for them to proceed to hear the substantive complaint. They will also need to bear in mind their own obligations under the Code of Conduct. The submission was made on Councillor Jones's behalf that the decision as to whether to proceed should be made by some other body. As I indicated earlier, that in my view is wholly misconceived. This is the body that is charged with considering the complaint, and it necessarily follows that this is the body that will first have to decide whether it should recuse itself. There is nothing odd or perverse about that. That is what standardly happens in tribunals and courts up and down the land when issues of conflict of interest or apparent bias are raised by a party. It falls to the tribunal to consider whether they should be recusing themselves. The various grounds for the application for either all or some of the members of the subcommittee to recuse themselves were advanced. The first, taking them not quite in the order that they were presented, but hopefully covering them all. The first was that members of this subcommittee were present at the full council meeting in November 2011 and did not object to a decision by the Asset Management and Land Disposal Committee to dispose of the Florence Road plot by way of a sealed bid. In my view, the fair-minded and informed observer would have in mind various matters. Firstly, that it's not suggested that any of the members of this subcommittee had an executive responsibility at the time in relation to that disposal. It is said that they were only attending the meeting as ordinary members of the council. If that was a ground for recusal, that would apply to everyone who was a member of the council at the time. Two, the fair-minded and informed observer would be aware that the members of this subcommittee are themselves bound by the Code of Conduct to approach matters in a fair and impartial way. The observer would also be aware that the AMLD committee made a decision following officer recommendation, that the decision was to dispose of the Florence Road plot in a manner that is different from the manner that is the disposal that was will be under consideration in the substantive dispute and is an entirely separate decision in relation to which no complaint is made against Councillor Jones. The observer would also be aware that the only objection that is made against the members of this subcommittee is that they were at the meeting and did not object to that disposal. Considering that overall, in my view, it is my advice to this committee is very unlikely that the fair-minded and informed observer could reach the view that there was any real possibility of bias on that ground. Taking the next point, that relates to Councillor Shackleton. She has put on record her understanding of the position, which was that the allegation there relates to matters that took place in around 2002-2003, so 15 to 16 years ago. She has said that she has not worked with Councillor Jones in Cabinet for a number of years and has not shown any animosity to him. Councillor Jones was afforded the opportunity to respond to the points made by Councillor Shackleton and the other members of the committee and didn't take up that opportunity. In my view, the fair-minded and informed observer would bear in mind not only the fact that the members of this committee are bound by the code, they would bear in mind that these matters happened a very long time ago, that there is no suggestion by Councillor Jones of any history of animosity despite both of them being on the Cabinet together, and that the decision to close the school was part of policy approved by the whole Council. Again, in my view, my advice to this committee is that it is most unlikely that the fair-minded and informed observer is unlikely would identify there being any real prospect of bias on those grounds. The next point is made that Councillor Troe, as Secretary of Labour Group, and Councillor Lewis, as Chair, were involved in a decision to refer a disciplinary complaint against Councillor Jones. Both Councillor Troe and Councillor Lewis have set out their understanding of events on the record. Again, Councillor Jones had the opportunity to respond to their account of events and took no and declined to take any specific point. Their explanation of the position was that the Chair and Secretary had no role under the party constitution in the referral. That was instigated by the Chief Whip, and then the relevant meeting was conducted by the Regional Labour Party. In my view, the fair-minded and informed observer would be aware of those facts. The observer would again be aware that the members of this subcommittee are bound themselves by the Code of Conduct. In my view, again, it is unlikely that the fair-minded and informed observer would reach the view that there was a real real possibility of bias on the basis of Councillor Troe and Councillor Lewis's involvement in those events. There was then further an allegation that all members of the subcommittee are somehow tainted by the fact that allegedly the members of the Standards Subcommittee are appointed by the leader and the executive. My advice to the committee is that appears to rest on a misconception. The Standards Committee is appointed by the full Council, and in any event, in my view, that would be an insufficient matter to lead the fair-minded and informed observer to consider that there was a real possibility of bias. I specifically asked Councillor Jones whether he was alleging that the members of the subcommittee were involved in any conspiracy or collusion to pursue allegations against him, and I didn't get a very clear answer on that. The next point that is made is that the members of the subcommittee also sat on the case involving Councillor Hussain. Now, in my view, the fair-minded and informed observer would take account of various matters. The fair-minded and informed observer would be aware that Councillor Jones was not subject to the complaint that was considered in Councillor Hussain's hearing. The Standards Subcommittee was not invited to and did not make any findings in relation to alleged misconduct by Councillor Jones. The fair-minded and informed observer will also be aware that that the allegation that is to be considered today involves a different series of events from those considered in Councillor Hussain's hearing. The fair-minded and informed observer will also be aware that I will shortly be giving my advice should the committee proceed with the allegations. I would be giving clear advice to them that they have to decide this case solely on the basis of the evidence before them in the hearing bundle and any evidence and submissions that they hear today or heard at the hearing on the 1st of December. They should put out of their minds any other matters that they may have seen or read in the press or indeed heard in a previous Standards Committee. And given that they are bound by the Code, there's an expectation that they would comply with such advice. On the other hand, the fair-minded and informed observer would be aware that there was certain mention of Councillor Jones in some of the evidence at the Hussein hearing, and that there is some reference to him in the documents that the committee considered on that occasion, and that they will have had to consider one instance in which there is some involvement alleged by Councillor Jones. That might be said to tip the balance the other way. The fair-minded observer will, however, also be aware that there are extensive references to Councillor Jones's alleged involvement in the other matter in public documents, such as, in particular, the judgment of Mr. Justice Green in Councillor Hussein's unsuccessful judicial review of the council, where there are a number of references, and there was no, although the recordings of the Councillor Hussein's hearing are available on the internet, and the correspondence bundle shows that the monitoring officer referred the committee to referred Councillor Jones's representative to those. Councillor Jones made no specific reference to any particular passage in the evidence that was adduced at Councillor Hussein's hearing that is said to be particularly likely to taint the committee. So on balance, my view is that, again, the fair-minded and informed observer is unlikely to consider that there is a real possibility of bias on the part of the subcommittee. But ultimately, it is a matter for the subcommittee to consider themselves whether they are properly able to put aside any information they may have from other sources, in particular the Councillor Hussein hearing, and consider the matter purely on the basis of what they hear today. If they have any doubt as to their ability to do that, then they should recuse themselves. So that's my advice in relation to conflict of interest. Perhaps one further point I should make is that the authorities, the case law is clear in relation to bias, that a tribunal should be particularly robust if there is any suggestion that the manner in which an application for recusal is pursued should itself be seen as a basis for bias or prejudice. The tribunal should be robust, and if it decides that there is no substantive basis for recusal, the way in which a recusal application itself is pursued, things that may be said about the tribunal, should very rarely themselves constitute a proper basis for recusal. Turning now to more general points about adjournment, I've given advice in relation to adjournment at the last hearing on the 1st of December 2017. Clearly, if the committee decides they need to recuse themselves, then that will almost inevitably lead to an adjournment. But I consider the other matters briefly. The subcommittee will need to engage ultimately in a balancing exercise. They will need to consider all the relevant circumstances of the case. They will need to balance fairness to the party seeking the adjournment against the public interest in proceedings being conducted in an expeditious manner, and indeed the interest of the council in having a standards complaint resolved expeditiously. The subcommittee will need to consider, as part of the relevant circumstances, the history of the present application, and will need to consider a number of matters. The first of those is that the arrangements that the council has for deciding standards complaints provide that normally a hearing will take place within 6 weeks of referral. In this case, Councillor Jones has had over 10 weeks in which to prepare, and indeed nearly 7 weeks since the hearing was adjourned at his request. This is obviously not, second point is, this is obviously not the first adjournment. The subcommittee was persuaded on the 1st of December to adjourn the hearing. It said in its reasons that it was just persuaded to adjourn, and that was on the basis of Councillor Jones's request for a 3 to 4 week adjournment. The subcommittee will need to consider the correspondence that's taken place subsequently, and the directions that have been given in relation to preparation for the case. The subcommittees also will need to consider the complexity of the actual case that is before it. On one view, there is a fairly narrow, if any, degree of factual dispute. The issue appears really to be one of dispute about whether or not what Councillor Jones did or didn't do in 2011 constitutes a failure to comply with the Code of Conduct then in force. Councillor Jones has intimated an intention to call various witnesses and seeks to argue that the whole process was politically motivated. In my submission, the subcommittee is entitled to interrogate that submission with some rigour. The subcommittee, at its last hearing in its reasons for adjournment, specifically highlighted its concern that there was no obvious relevance to the matters that Councillor Jones was raising. Mr Tompkinson was in the process of trying to explore that point with Councillor Jones this morning when Councillor Jones decided to leave the hearing. But it is in my submission, my advice, highly pertinent. If Councillor Jones is seeking to advance matters that are not relevant, then it is unlikely to be a weighty matter in justifying a further adjournment. Turning now to the further reasons that are said to justify adjournment, they appear to be essentially this: that Councillor Jones was provided with further documentation at the last minute. As I think he conceded, it was reasonable to be provided with correspondence which had indeed either been received by or emanated from his various representatives. And then there is the scheme of delegation. As Mr Dennis pointed out, on one view, only a very small part of that is relevant. Then there was the point about witnesses, which I've already referred to. There was no clear identification of what these witnesses would actually give evidence on. No witness statements have been provided, and apparently no attempt has been made by Councillor Jones to take the initiative and approach any of these witnesses. The committee may well wish to take that into consideration in determining whether the further time to get witnesses ready is an appropriate basis for yet further adjournment. So, as I say, ultimately it's a question of balancing exercise between these various factors, trying to achieve fairness for Councillor Jones, who is requesting the adjournment, versus the public interest, and fairness to the Council in having the complaint resolved in a timely manner. Mr Dennis, have you got any comments on my advice?
No, I have nothing to add.
I should add that Councillor Jones and his representative stayed. I've obviously afforded them the opportunity to make any observations on my advice, but they've not taken up that opportunity.
Yes, of that, Mr Cornwell. We'll now adjourn over lunch, and I think we'll reconvene at 1:30 and over the deliberations that we take as to whether Councillor Jones' submission for adjournment or whether we proceed with the hearing. And we'll adjourn again 1:30 p.m. Thank you. The subcommittee has deliberated over lunch, and we have reached the decision that the subcommittee come to the conclusion that it will hear the case in Councillor Jones's absence. He did decide before lunch that he would leave the meeting, which he did, and consequently we have deliberated and we're going to hear the case in his absence. Thank you. I'll now hand you over to Mr Cornwell for a statement, please. Thank you.
Yes, this is just a brief summary of the subcommittee's reasons which they've asked me to relate. The full reasons will be set out in the decision notice in due course. Given the time, this is fairly a brief summary. This is a decision of the 4 members of the subcommittee who have been advised by the independent person and their legal advisor. The subcommittee has considered the application to adjourn the hearing and to recuse themselves. The subcommittee took account of the views of the independent person and the advice of the legal advisor, and the submissions of both Councillor Jones and Mr. Ronnie Dennis on behalf of the investigating officer. None of the members considered that they needed to recuse themselves. The subcommittee will set out its reasons in full in the decision notice. The subcommittee also unanimously considered that no further adjournment of the hearing that a further adjournment of the hearing should be refused. Again, full reasons will be set out in the decision notice. So I think the procedure is that Mr. Dennis will now introduce the case for the investigating officer. He's got no witnesses, so once he has finished his submissions, then if the subcommittee have any, or the independent person or myself have any questions, we can ask him. Then the independent person will give his views, and I will give my advice, and then the subcommittee will proceed to deliberate.
Mr. Dennis, thank you. You're now the opportunity to proceed with your investigation. Thank you.
Thank you, Chair. You may recall that during the last hearing, or at the outset of the last hearing, I handed up a written note entitled Opening Summary. I'm just handing up copies of that again now. That's exactly the same document as you had before. So what I propose to do is to take you through this and to take you to some of the key documents in the course of doing so. Paragraph 1, as you'll see, sets out the allegation. That's the only allegation before you that I've referred to a few times already, and it's really the last 2 lines in that paragraph that Councillor Jones breached the code in the ways I'll come on to describe in relation to his role in the removal of a plot of land for sale at Florence Road, Smethwick. You'll see paragraph 2 sets out the investigating officer's conclusions as set out in the report in respect of that allegation, specifically that Councillor Jones, that the evidence establishes a potential breach of the code for the reason that's set out there with Roman numeral 1. Councillor Jones did not question the instruction of the then leader, Councillor Cooper, for the removal of the plot of land from auction, as would be expected of the Cabinet member with the responsibility for land and assets, as he then was, in discharging his duties. Councillor Jones had been alerted to the fact that the plot had a considerable amount of interest and may have achieved a higher sale price had it proceeded to auction. So that's the crux of our findings in respect of the allegation. And you then see there the 2 breaches of the Code of Conduct. First, that Councillor Jones conducted himself in a manner which could reasonably be regarded as bringing his office into disrepute. And second, that his behaviour may have compromised, or was likely to compromise, the impartiality of those who work for or on behalf of the authority. So, turning over to my paragraph 4, this is under the heading The Facts. The first document I'd like to take you to is in the main bundle. Most of the documents are in the main bundle, and that's at tab 18, page 256. Uh, 256. So you see there a note from the Director of Strategic Resources to the Director of Legal and Governance Services, matter being dealt with by Kerry Jones, 4th February 2011, land off Florence Road. I hereby attach a copy of my report in relation to disposal of the freehold interest in the above parcel of land. And then the next paragraph, it is intended that the property will be sold at an auction scheduled to take place on 10th March 2011 by the Council's appointed auctioneer Bigwoods. And then the last paragraph, finally, I should be grateful if you would make arrangements for attendance at the auction by the appropriate conveyancer. And you can see it's signed off Kerry Jones, Property Review Officer. And then turning through to tab 19, page 258. You see here a report. You can see top left corner, Cabinet Member Jobs and Economy. That's Councillor Jones at the time. Purpose of report to dispose of freehold interest, address of land, land off Florence Road, Smethwick. Purchaser's name and address to be confirmed at the auction. Then turning over the page, 259. At the top of the page, interest to be disposed of, freehold. And then the penultimate paragraph at the bottom of 259. This matter is forwarded to you in accordance with the authority delegated to the Director of Strategic Resources in the scheme of delegation approved by full council at its meeting on 30 November 2010. The minute refers. You'll have heard reference this morning to the scheme of delegation. I'd just like to take you to that. That's in the other bundle. That's the only document I'd like to take you to in the other bundle. But the correspondence bundle, the scheme of delegation begins at page 78. And if you turn through that to page 97, you'll see the way this is set out is that you have the various officer roles at the top of the page, followed by their delegated authority, a list of the matters in respect of which they have delegated authority. Page 97 is one of the pages in respect of the Director of Strategic Resources. And it's the last two entries on page 97. You see there that the Director of Strategic Resources had authority for the disposal of land and property, that is to negotiate for and agree terms for the disposal of land and property in accordance with such policy as may be determined by the Council, and disposal of land and premises up to £100,000 in consultation with the appropriate Director to negotiate and agree terms for the disposal of areas of land and premises up to a value of £100,000. There's two other documents I'd like to take you to on this, the subject of who had the authority to authorise disposal by public auction or otherwise. The first, and you can put that bundle away now, indeed it might be easy for you to take page 97 out and keep it to one side, since that's the only page from the scheme of delegation that's relevant for present purposes. But back in the main bundle, the next reference is page 334. And that's at tab 40. Tab 40, page 334. So you'll see this is a much more recent letter. This in fact sets out Councillor Jones' response to the investigation report. It's from his previous representative, Mr. Bloom. And at paragraph 2, page 334, Mr. Bloom writes, by acting merely as a conduit for the leader's request, and in fact, and this is the reason I've taken to this letter, having no authority to exercise to require the decision to auction to be overturned. See Audit Report, paragraph 3.4. So, Councillor Jones' own position, as we see here, is that he didn't have authority to overrule the decision taken by the Director of Strategic Resources that this property would be sold by public auction. You see that is the view expressed by his own representative. That's his position in his own defence. And there's reference there to paragraph 3.4, so we'll just go to that for completeness. The audit report to which he refers there is at tab 36. Page 310 is the first page of the audit report. So you can see this is draft internal audit report in relation to disposal of land at Florence Road. That's the land we're concerned about now, November 2016, and just turning through that to page 312. You'll see there paragraph 3.4 to which Councillor Jones's earlier representative referred in his letter. And what it says is that from our review of the Council's constitution at that time, we can find no reference to any legal authority that the leader of, or Councillor Jones had to countermand the decision made by the Director of Strategic Resources under the scheme of delegation. Also, from our review of the records available, we cannot see that the Director of Strategic Resources was informed of this decision. So, taking all of those documents in the round, it's clear, we say, that the only person with authority to decide whether this land be disposed of by way of public auction or not was the Director of Strategic Resources, and that once he'd taken that decision, neither the leader nor Councillor Jones had any authority to overrule him. The next document is at tab 21, that's page 262. So this is picking up the chronology again of what actually happened at the time. At 262, which is behind tab 21. Sorry, I'll stop giving you the tabs. Yeah. So page 262, you see there, you've seen the report that said that the land was to be disposed of at auction. This is an extract from the auction catalogue. So you can see lot 92, site at Florence Road, a freehold residential development site, guide price 34,000 to 38,000, and then a little further down the page in the left column, property description, a rectangular site which may be suitable for the erection of a single detached two-storey dwelling or possibly a pair of semi-detached dwellings suitable to obtaining necessary planning approvals, and that's something I'll come on to later or refer to again later. And then in the right-hand column, the last penultimate entry in the right-hand column is auctioneer's note. Please note that no offers will be accepted prior to auction. So here you see that as per the direction made by the Director of Strategic Resources, the land was advertised in the auction catalogue. However, before the auction took place, this is the 24th of February, we see an email from Matthew Lynch, and that's at page 264. So 264, this is the key email which I imagine you've seen before. It's from Matthew Lynch, who, as you can see from the email footer, was then Senior Development Surveyor, and it's to Councillor Jones. And Mr. Lynch says there, Councillor Jones, as per our conversation earlier, please you confirm that the leader has requested the removal of Florence Road from the auction on 10th March. So plainly, shortly before this email is sent, Councillor Jones has informed Mr. Lynch that the leader has requested the removal of the property from the auction. Mr. Lynch then says, I would be grateful if you could confirm the individual party involved to enable property services to progress this matter. The guide price published was 34,000 to 38,000, however the reserve was to be set at 45,000 on the basis of its suitability for the erection of two semi-detached houses. And then he says this, as discussed, I should point out that we have already had other inquiries in the site since the auction catalogue was published. Those parties have been informed that the site will go to auction, where they can submit bids. In this respect, there may be questions as to why it was removed and sold by way of private treaty. In addition, while I can confirm the reserve price was to be 45,000, my hope was that the competitive nature of the auction nature of the auction would increase the receipt for the council, as has happened in the past. So what we see here is Mr. Lynch raising concerns in his capacity as an officer. He's raising concerns with a member, Councillor Jones, that he doesn't think it's appropriate for this property to be removed from auction. He sets out those reasons in this email, that they've already had other inquiries, that other parties have been told they can submit bids at the auction, and that he hopes that the nature of the competitive process at an auction will allow the council to achieve a higher price for the property. So that's what Mr. Lynch is doing there. He's raising concerns with Councillor Jones about this instruction that he's passed on from the leader. If you then turn over, we see Councillor Jones's reply on page 263, so back a page. Now, as I said earlier, Councillor Jones was at this time Cabinet Member for Jobs and Economy. I'll just give you the references for that because it's confirmed in the documents, but you don't need to go to them now. It's page 312 and 331. So in that role as Cabinet Member for Jobs and Economy, he has responsibility for land and assets. You see that in those two references. In other words, he ought to know the proper processes, and he ought to be put on notice that there's something potentially wrong, having received Mr. Lynch's email. However, as you see on page 263, Councillor Jones replies, "Hi Matt, I will get the inquirer's name and contact details and ask them to contact you directly so that you can discuss the sale details." He doesn't there respond to any of the concerns that Mr. Lynch has raised. Indeed, he ignores them completely. And if you then turn over to page 265, you see there an email from the following day. Again, Councillor Jones to Mr. Lynch says, "Hi Matt, the name of the interested party is Mr. Ahmed," and then his address and telephone number. So Councillor Jones doesn't respond to Mr. Lynch's concerns. Instead, he just passes on the instruction from the leader, and as we'll see in a moment, does so without questioning the leader at all. You'll see the top of my page 3, paragraph 9, refers again to the draft internal audit report, which I took you to earlier, to make the point that Councillor Jones and indeed the leader had no authority to countermand the decision made by the Director of Strategic Resources to refer the property for sale at auction. I also refer there to paragraph 311, which says that such practice would also not demonstrate best value, as the price agreed was set at the reserve price, that is the reserve price at the auction, and would not allow the competitiveness of the market to determine the final outcome. Now, this is a slightly different point to the one about the scheme of delegation, and this is a reference to the Council's duty to obtain best consideration or best value on a land disposal. And you see that in my paragraph 10, it's section 123, subparagraph 2 of the Local Government Act 1972, which says that, except with the consent of the Secretary of State, which of course wasn't obtained here, a council shall not dispose of land under this section otherwise than by way of a short tenancy for a consideration less than the best that can reasonably be obtained. Now, the council's duty under that section could of course be satisfied by carrying out a public auction, because at a public auction any interested parties could bid, and the public nature of the process would ensure that best consideration, that the best price reasonably obtainable was obtained. Contrariwise, taking the property out of a public auction and selling it direct to one individual without any public competition could not be guaranteed to achieve best consideration, precisely because there would be no open public competition for the sale. Now, I refer then to something that Councillor Jones said during his interview with Miss Price, the investigating officer, and it's worth turning that up. That's at page 332. So the notes of this interview start at 331. Indeed, at 331 you'll see, as I mentioned earlier, the first question, were you the Cabinet member responsible for the property portfolio in 2011? Councillor Jones replied, yes, I think that I was. And then over the page to 332, question 8, Councillor Jones was asked, did you speak to the leader about this or ask why it was removed from auction? He replied, I can't remember speaking to the leader and ward member at all about this. It was not my instruction to remove the property. This definitely reads as the leader's instruction, not mine. And then this is the crucial passage. If the leader says it's okay, it's okay. I didn't question and assumed everything was in order. It's not usual for a ward member to approach a cabinet member on things like this with the cabinet member as an intermediary. I assume that you just dealt with it as the ward member. And then he's asked, was this the normal practice? He said no, but I would not have questioned the leader. I did not know what he had agreed or what process was followed. Question 10. On 24th February you were asked for details of the buyer. Do you recall this? No, I must have spoken to the leader. I don't remember, but I did not know the buyer, so I must have asked someone for details. Question 11. Did you question why it was removed from auction? No. So Councillor Jones's own position is that he didn't question the leader's instruction to remove the property from the auction. That is, despite neither he nor the leader having authority to take that decision, and despite the risk that the council wouldn't obtain best consideration as a result of not following an open public process. Now, back to my written note, you'll see my paragraph 12. The investigation report, that is, records that this would appear to be the end of the involvement of Councillor Jones in the sale of the land. So the crux of this case is the email you've seen and Councillor Jones' own account that he didn't question the leader's instruction. And then just to complete the timeline, the chronology, my paragraph 13, there was then an offer made to Mr. Ahmed, the purchaser referred by Councillor Jones, an offer to him to sell the land for £45,000, and we see that at page 266. If you'd just like to turn up 266. So you see here, letter to Mr. Ahmed, 1st March 2011, subject to contract. Further to your conversation with and at the request of Councillor Cooper, the leader of the council, I can confirm that the council are prepared to dispose of the above site subject to the following terms. Consideration £45,000. A few paragraphs down, you'll note that the consideration is higher than that of the quoted guide price. The guide price is designed to attract interest in the site at auction. The consideration is the reserve price and represents the lowest at which the council is willing to sell. This price would have been set as the reserve had the site progressed to auction, and of course you've seen the surveyor saying he was hopeful that a higher price could have been obtained through that process, a price above the reserve. Mr. Ahmed is asked to confirm acceptance. Over the page 267 you see a letter from Mr. Ahmed saying, thank you for your correspondence. I would like to confirm acceptance of the offer of £45,000 for this site. Please could we commence with the legal procedures? So there's an offer and an acceptance. That's how close the contract gets to being completed. In fact, the sale for whatever reason isn't completed, and instead the land is later sold through a sealed bid process. We see that at page 286. Or rather, we see the winning bid at 286. So you can see 286 is an individual building plot's sealed offer form, and there you can see the price is 65,000, so £20,000 more than the agreement with Mr. Ahmed, which demonstrates that when there was an open competitive process, a higher price was achieved. So it goes back to the point I made earlier, that without an open competitive process, the council couldn't be confident that best consideration would be achieved. And then the last document is at page 313. And this is back to the audit report, and indeed You see at 311, the point I've just been making, such practice would also not demonstrate best value as the price agreed was set at the reserve price and would not allow the competitiveness of the market to determine the final outcome. While this sale did not ultimately go ahead, the plot of land was later sold through a sealed bid process for $65,000, which is considerably higher than the price earlier agreed by private treaty. So those are the facts, and turning now to Councillor Jones' breaches of the code in respect of his involvement. Just before I take you to what we say were Councillor Jones's breaches of the code, I'm conscious that during a recent hearing, Mr. Tompkinson asked whether there was any evidence of training on the Code of Conduct or knowledge of the Code of Conduct for the member concerned. And with that in mind, we've dug out a declaration from Councillor Jones to the effect that he undertook to observe the Code as to conduct, which is expected of members of the Borough Council of Sandwell. So you see there, declaration of acceptance of office. I, Ian Stephen Jones, having been elected to the office of Councillor, declare that I take that office upon myself and will duly and faithfully fulfil the duties of it according to the best of my judgment and ability. I undertake to observe the code as to conduct which is expected of members of the Borough Council of Sandwell, and it's dated 2nd May 2018, so before this incident. Sorry, 2008. And you can see there it's signed by him. So that's Councillor Jones' knowledge of the code, and then picking up at my paragraph 16, you'll see the first provision from the code in force at the time to which we refer is that you must not conduct yourself in a manner which could reasonably be regarded as bringing your office or authority into disrepute, and you see that at page 104. Now, in the respects I've already outlined, we say Councillor Jones' conduct could reasonably be regarded as bringing his office and or the council into disrepute, and I set out the reasons there in 4 paragraphs. The first, that at the time he was, as we've seen, the cabinet member responsible for the council's property portfolio, and therefore had some responsibility for ensuring that the council complied with its various statutory duties in respect of that portfolio. My paragraph B, as I've also said, the council has a statutory duty not to dispose of land for less than best consideration. Best consideration could have been achieved by selling the land at auction. Councillor Jones could not be confident that it would be achieved by removing the land from auction. Indeed, he ought to have suspected when the leader proposed to him that the land be removed that best consideration would not be achieved, precisely because there would not be an open competition. He did not take any steps to reassure himself that best consideration would be achieved. As we've seen on his own account, he did not question the leader's instruction. Paragraph C, this is the point about delegation, that the officers, in this case the Director of Strategic Resources, had the authority to make this decision. Neither the leader nor Councillor Jones had authority to override that decision. My paragraph D makes the general point that openness and transparency in connection with the use and sale of public assets is of course important for the public. It's important for the council to behave in a way that is open and transparent when it takes decisions over the sale or use of publicly owned assets. This sale to a private party shortly before the land was due to be included in a public auction was neither open nor transparent, and in this respect Councillor Jones was at least complicit in the leader's decision to remove the land, because as we've seen he did not question it. My paragraph 17, I refer to the guide for members which accompanies the code, and if I could just refer you then in that respect to page 72, which is a page from the guide. So the guide begins at 67, and and the relevant page is 72. So you see here the 10 general principles of public life, and the guide says that the Standards Board recommends that your local authority includes a preamble to the code that it adopts, which outlines the 10 general principles governing the conduct of members of local authorities. And in the next paragraph, these principles define the standards that members should uphold and serve as a reminder of the purpose of the code of conduct. As these principles do not create a statutory obligation for members, the Standards Board cannot accept allegations that they have been breached. However, you should be aware, that is members, that a failure to act in accordance with these general principles may amount to a breach of the code of conduct. For example, by placing yourself in situations where your honesty and integrity may be questioned, your conduct may be conduct which could reasonably be regarded as bringing a member's office or authority into disrepute, as stated in paragraph 5. So the general principles are not themselves actionable in the sense that if you breach them, you're not breaching the code. However, if you breach the principles, it may follow that by doing so, you are also in breach of a particular paragraph in the code. In this case, we say there's a breach of that paragraph 5, that you must not conduct yourself in a manner which could reasonably be regarded as bringing your office or authority into disrepute. And when you're asking yourselves what sort of behaviour might have that effect, it is helpful to have in mind the 10 general principles of public life as set out there in the guide. Now those are at page 112. So that's back in the Code of Conduct in force at the time, which begins at 101. And if you turn through that, you see the general principles at 112. You'll see in my paragraph 18, I set out the various principles that we say Councillor Jones failed to comply with. First, that of honesty and integrity, that members should not place themselves in situations where their honesty and integrity may be questioned, should not behave improperly, and should on all occasions avoid the appearance of such behaviour. We say that by passing on the leader's instruction for a private sale without question, Councillor Hussain did place himself in a situation where his Councillor Jones did place himself in a situation where his honesty and integrity may be questioned. Then you see at paragraph 5, openness. Members should be as open as possible about their actions and those of their authority, and should be prepared to give reasons for those actions. Again, as I've already said, Councillor Jones' actions in this case were not open in any way. Indeed, he simply passed on an instruction for a private sale without question. Paragraph 6, that members may take account of the views of others, including their political groups, but should reach their own conclusions on the issues before them and act in accordance with those conclusions. Well, plainly, by his own admission, Councillor Jones did not exercise his own judgment, his own personal judgment, did not reach his own conclusions on this. His position is that he simply passed on the leader's instruction without question. Paragraph 8 over the page, the duty to uphold the law. Members should uphold the law and on all occasions act in accordance with the trust that the public is entitled to place in them. Again, that goes to the point I made about the duty incumbent on the council to obtain best consideration. Councillor Jones did not do all that he ought to have done to uphold the council's compliance with that provision. Stewardship, that members should do whatever they are able to do to ensure that their authorities use their resources prudently and in accordance with the law. Again, Councillor Jones did not do whatever he was able to do. Indeed, he didn't do anything at all to ensure that the council used this property prudently and in accordance with the law. And finally, leadership. Members should promote and support these principles by leadership and by example, and should act in a way that secures or preserves public confidence. Now, in this respect, at least, Councillor Jones does appear to accept that he's failed to comply with the principles, and we see that at page 335, which is back to his written response to the investigating officer's report. So 335, just above the header, the wider issues, Councillor Jones' representative says, even on the facts of the report as found, it would seem to be that the potential breach could only relate to a failure to demonstrate leadership in respect of the actions of others. So at least in this, one narrow respect, Councillor Jones accepts that he failed to comply with the principles. We say that because he failed to comply with those principles, honesty and integrity, openness, personal judgment, duty to uphold the law, stewardship and leadership, he behaved in a way that could reasonably be regarded as bringing the council and his authority, his office and the authority, the council, into disrepute. So by failing to comply with those principles, he also breached that paragraph of the code. There's then the second paragraph of the code that we say Councillor Jones breached. That's paragraph 3.2d, as I've set out there above my paragraph 19. You must not do anything which compromises or is likely to compromise the impartiality of those who work for or on behalf of your authority. Councillor Jones' conduct, as we've looked at, either compromised or is at least likely to compromise the impartiality of Mr. Lynch, who was the author of the email querying the proposed sale to a private party, in which Mr. Lynch set out his concerns. In that email, Mr. Lynch set out his reasons why he was concerned about the proposal for a private sale, that the council couldn't be confident it would obtain the best value because there would be no public competition, and that the council had had expressions of interest from others. So you can see in that email that, acting impartially, Mr. Lynch's first reaction to this instruction was to question it, to say we ought not to be doing this, there's no good reason why it doesn't go to public auction, and there's good reason why it ought to go to public auction. That was his first reaction. In his reply, as we've seen, Councillor Jones did not address Mr. Lynch's concerns. Instead, he just provided the name of the proposed purchaser and their details. In doing so, Councillor Jones's conduct was at least likely to, and indeed did, compromise Mr. Lynch's impartiality, because Councillor Jones encouraged and indeed facilitated Mr. Lynch's actions in then going ahead to proceed with the sale to a private party against his better judgment. Thank you, Chair.
Thank you, Mr. Dennis. Is there any questions at all from the panel? Start with you, Mr. Corman. Start with you, please.
Thank you, Chairman. I have a number of questions, Mr. Dennis. Thank you very much indeed for providing confirmation that Councillor Jones would have been aware of the statutory code that was in place at the time. Could you, if possible, confirm to me whether or not, to your knowledge, Councillor Jones had training in the code of conduct that applied at that time?
I'm afraid I don't know is the answer to that question. Of course, he has signed a declaration to say that he undertakes to observe it, so he knew what his obligations were.
Could you confirm for me, please, when Councillor Jones was appointed as the Cabinet Member for Land and Assets? Sorry, Jobs and Economy. Sorry, my apologies.
I think the most efficient course might be for us to dig that data. He was certainly appointed before the events to which the allegation relates.
Okay, perhaps you may want to dig this out as well as a piece of evidence. Was he receiving a special responsibility payment for his role as a Cabinet Member at that time? when he was appointed, and during that period that we're discussing, February 2011, was there a job description of any kind that related to that role? And to your knowledge, did he receive a briefing on his role as cabinet member at that stage when he was appointed? And then on the back of that, in particular, related to best value and best consideration. Okay, putting that to one side, can I turn to your scheme of delegation to officers in the correspondence bundle, page 78 onwards? I recognise that this morning you diverted our attention to 2 pages in that document. I wonder if you could, for my benefit, explain the implication of the content of this document for my consideration of this matter.
Yes, certainly. So the 2 pages to which I referred earlier are the same as the 2 to which I referred just now. They are page 78, which is the first page, and page 97, which is one of the pages that sets out the delegation of authority to the Director of Strategic Resources. You see that at the head of the page. And it's the last 2 entries on that page: disposal of land and property, to negotiate for and agree terms for the disposal of land and property in accordance with such policy as may be determined by the Council, and then disposal of land and premises up to £100,000 in consultation with the appropriate directors to negotiate and agree terms for the disposal of areas of land and premises up to a value of £100,000. So the point here is that the cabinet member, the Director of Strategic Resources had delegated to him the authority to sanction disposals of land and property. He exercised that authority, as we've seen, by instructing the Director of Legal Services to sell the land at public auction. He was the only one who had authority to make that decision. Neither Councillor Jones nor the leader at the time, Councillor Cooper, had authority to override that decision. And that's one of the reasons why we say that in doing so, Councillor Jones breached the code, because the Council has a scheme of delegation to officers to ensure that its public powers are properly exercised by those with responsibility for them. The relevant officer had taken a decision, which was the right decision, it seems, under the circumstances, to sell at public auction, because that would enable a public competitive process to help the Council to achieve best consideration. And Councillor Jones, albeit by passing on the leader's instruction rather than acting of his own initiative, overrode that decision that had been properly taken by the Director of Strategic Resources.
Could you please confirm for me when the plot of land in Florence Road declared surplus to requirements?
So this is covered by the draft internal audit report to which I referred, page 311. Paragraph 3.1, I don't think this quite answers your question, but I think it answers in a slightly different way, which is how did this property come up for sale. 3.1, in 2002 a compulsory purchase order was placed on a group of 8 Victorian terraced houses in Florence Road, Smethwick, due to the properties being unfit for habitation. The properties were subsequently demolished, but the land was not developed for a number of years. We understand one of the reasons it was put on hold was because an electricity substation was also located on the land. From the records available, it is not clear as to what the exact trigger was to finally dispose of the land, I think is the answer to your question, a number of years later. However, it appears likely that it was part of a move, in all probability financially driven, in order to increase income, to identify and sell off small pieces of unused land that was held by the council. And it then goes on 4th February 2011, a property review officer, and that's the document that we've already seen.
Referring to that document, I wonder if you could explain to me how, based on the investigation that Ms. Price conducted, could you explain to me how knowledge of the plan to take this site to auction, as outlined in that memorandum of the 4th of February, became known to the leader?
I've just been checking to see if there's an answer in the documents. We don't have an answer, and of course we've not been able to ask the leader at the time. And it doesn't appear that there's an answer in the documents either. Okay, so I can take from that internally within the council, on the 4th of February, going to auction was known about, that presumably instructions were dealt with the auctioneers, and that somehow knowledge became known to the then leader. Is that correct? Is that the chronology I should take? Yes.
Okay, I wonder if you could advise me, again based on Ms. Price's investigation, whether prior to the 24th of February there is any evidence that Councillor Jones, in his role as Cabinet Member, was advised of the proposals for the disposal of the land in Florence Road.
No, the first time we see Councillor Jones referred to is at 264, the email from Matthew Lynch.
Thank you. So I can take it then that Councillor Jones had no knowledge of this specific sale or put to auction until it was raised with him by the then leader.
As far as we know, on the basis of the documents and Councillor Jones' own account, his first involvement is when he has a conversation with Mr. Lynch shortly before the email of 24th February, as recorded in that email, when he tells Mr. Lynch that the land is to be removed from the auction, then due to take place on the 10th of March.
Okay. The draft internal audit report, page 310, in the bundle onwards, talks about the fact that the internal auditor finds no reference to any legal authority the leader or Councillor Jones had to countermount the decision. Would you not accept the argument that the leader, as ultimately in control of the council, i.e. the leader of the council, has the ability to instruct officers as he feels appropriate and in accordance with the law and with the need for implementation of the council's policy?
We'd agree, I think, that the leader may discuss with officers policy considerations affecting how they exercise their delegated powers, but what he can't do, what he ought not to have done, is to instruct an officer about how to exercise that officer's powers. The officer has delegated powers. and as we've seen from the Code of Conduct, members are not to impugn the impartiality of those officers when exercising their powers. So Councillor Cooper went too far, we say, by instructing the officer in this circumstances to remove the property from the auction.
Going on from that, did your investigation give you any explanation as to why the Director of Strategic Resources was not informed of the decision to withdraw from auction?
I'm afraid we don't know the answer to that. One of the difficulties that we've had is that the relevant individuals have left. So Mr. Lynch no longer works at the council. The Director of Strategic Resources at the time, Nick Bubbalo, also had left the council by the time of the investigation.
In your investigation in the officer's report, there's a considerable amount of material related to the period after the first sale collapsed. I'm curious as to why you felt the need to include that when your conclusions relate almost exclusively to the period of February 2011. I wonder if you can enlighten me, please.
Yes, as part of the investigation, a large number of documents were collated, as you've seen. As the investigation has gone on, as we've taken Councillor Jones's account, it's become apparent that, as far as we know, his involvement ended shortly after that exchange of emails. So, although that later material, it appeared, might be relevant at an earlier stage, it now appears that it's not relevant and it's not part of our case that he breached the code, which relies on the earlier documentary evidence.
Thank you, Chair.
Thank you, Mr. Tompkinson. Councillor Shackleton, any questions at all, please?
I've just got one, just for clarification. I know we've had a lot of reading, but the 45,000 was agreed for the purchaser, Mr. Ahmed, and he replied accepting the offer. Then we know that the land was later sold through a sealed bid process for 20,000 more. Who would have initiated that process and why? Because already we've got an extra 20,000. Were they realising the best value hadn't been achieved, or who would have sanctioned that? Thank you.
We see that at page 281, and that's a report that starts at page 275. So if you'd like to turn up 275. We see there a report of the Asset Management and Land Disposal Committee, Thursday 27th October 2011. Present, Councillors Ealing, Hussain and Jones. And then turning through the pages to 281, the plots were to be sold freehold on a sealed offer basis and were only selected for disposal under this process known as individual building plots if certain criteria were satisfied, and then down towards the end of that page, the following sites have been identified as being suitable to be offered for disposal as individual building plots, that is by sealed offer, sealed bid process, as we see at the opening paragraph. And the third entry from the bottom on that page, 281, is the land off Florence Road, Smethwick, which is the land with which we're concerned. Of course, the other point, of course, that this is one of the ways in which the council can be confident that it is achieving best, because this is an open, competitive process, much like an auction, the difference being that bids are sealed.
I still don't understand why individual purchasers, why his offer was rejected. Does that make sense?
Yes, we've not been able to ascertain why that transaction fell through. The offer and acceptance are what's called subject to contract, so there was no binding contract at that point that was enforceable. But for whatever reason, the contract was never completed, and I'm afraid we don't know why.
Mr. Cornwell, any questions, please? I have one question. If I can refer and ask the hearing to turn to page 331, please, on the core bundle. Thank you. On the top of page 331, it goes on to say, notes of the interview with Councillor Ian Jones and Ben Henry on the 29th of September 2017, and investigator Ms. Maria Price. Councillor Jones wanted it recording that he did not believe that he had been given access to an independent person as part of the process, and that he should have been given the right, so the process is flawed. Was there any response at all, please, Maria, to that statement from Councillor Jones?
Yes, we did at the time. We sort of misunderstood the process a little bit. So he was referring to, or doing analysis between himself and the assaying case and what had been said during the judicial review proceedings. I formally responded back to his representative. He did have access to the independent, but that was following the investigation had started. He seemed to think that he should have an independent involvement with his interview in the other stages. Where I referred back to the arrangements and what we said within the arrangements, and the arrangements were complied with, and he was provided with contact details for both independents during the process, but he wanted that recording when I interviewed him, which is why it's recorded on the sheet.
Thank you, Ms. Price. Councillor Compton, any questions, please? Mr. Steve Crowe, Steve Crowe, please.
Yes, thank you, Chair. Can I go back to just to be absolutely clear about the nature of the breaches of the code that you're identifying here? You've identified in your statement, Mr. Dennis, the opening statement, that the first of those would be you must not conduct yourself in a manner which could reasonably be regarded as bringing your office or authority into disrepute, on page 4. Now, the points that you list there, especially B, C and D, am I to understand it that we should consider those points severally rather than being contingent on each other? I'm just trying to be clear about whether if, as you contend, there's a failure to achieve best consideration and a deliberate failure to do so, that in itself would constitute a breach of that code. It's not contingent on also being evident that this was as a result of directly and improperly overruling someone else's authority. The two things, and if that one only applies, the other one doesn't, then so we consider them severally.
Yes, that's absolutely right. In legal terms, legal drafting terms, there ought to be an and/or between paragraphs C and D. If you're satisfied that Councillor Jones failed in any of the ways I've set out in B, C or D, then you ought to find that he thereby behaved in a way that could be regarded as bringing his office into disrepute.
Thanks very much. The reason I'd asked that question was because the only authoritative documentation I found that confirmed that there was no authority with the leader or with the cabinet member was a judgment in a paragraph of the Audit Committee report. I didn't see a direct reference to statute anywhere, unless you can give me one now.
I think that's another thing to add to our list to follow up on.
No, sorry, can I also ask a further question? Referring back to the investigating officer's report, I'm afraid I haven't got page numbers on mine now, but it's the front of the evidence bundle. I think at the bottom of mine it says page P is one. It's the agreed facts. And the third paragraph down says, on or around the 24th of February 2011, the leader, Darren Cooper, instructed officers to remove the plot from auction and sell to a private buyer. This is supported by documentary evidence. Councillor Jones gave clear evidence that he did not give the instruction to remove the plot from the auction and was acting on the leader's instruction. Can we just interrogate that sentence in a way that makes it clear who was instructing whom in this? Because it seems to be suggesting both that Councillor Jones was being instructed by the leader and that the leader was instructing officers. And the reason I ask this question in particular, although I don't see it as necessarily material to the decisions we need to make about Councillor Jones's behaviour, I do think as a Standards Committee responsible for the integrity and reputation of this Council, that since Councillor Cooper, sadly, is no longer with us, that we should be absolutely clear, if there are allegations made about his behaviour in this, that there is clear evidence, which is what's stated in the investigating officer's report, and there is clear documentation that these are instructions that were given by the leader. I can't see any evidence for that so far, other than in 264, is it, page 2, on the email of the 24th. That only tells me that the officer was asked to remove this plot from auction, and he was told that it was on the instruction of the leader by Councillor Jones. That's the only evidence I can see that, and I wonder, since you're so clear that there's clear documentation, there's clear evidence, and it's an agreed fact, whether I've missed something in any of the documentation which demonstrates that this was an instruction of the leader and who he gave that instruction to.
No, I don't think you've missed anything. The relevant email is the one from the officer to Councillor Jones saying further to your instruction on behalf of the leader, or further to the leader's instruction that you've passed on to me. That's the sum total of it. And in that respect, the opening paragraph of that, the opening sentence of that paragraph, that on or around 24th February 2011, the leader, Darren Cooper, instructed officers to remove the plot from auction and sell to a private buyer, ought perhaps to be clarified. That refers to the same email. So on or around 24th February 2011, Councillor Jones relayed to an officer that Councillor Cooper had instructed that the property be removed. But whether or not that there is, of course, also reference to the to conversations with Councillor Cooper in the offer letter at 266, you'll recall, which begins further to your conversation with and at the request of Councillor Darren Cooper. I can confirm that the Councillor prepared to dispose of the above site. and that's the letter that's sent out to the buyer. But to answer your question succinctly, the allegations, of course, are only against Councillor Jones today. Those are the only allegations you're asked to determine. It's Councillor Jones' position that he was given the instruction by the leader. The documentary evidence supports that, and that's as far as you probably need to go for today's purposes.
Thank you, Mr. Dennis. As I said, I do appreciate that whether this instruction was given from the leader or whether there was no instruction from the leader, the matter that we need to consider is still Councillor Jones's behaviour. But you'll understand it's a matter of some concern that we seek to test allegations against the reputation of members who are not here to defend themselves any longer. And I was going to follow on to the letter on page 266, the following letter, which refers again to it being an instruction of the leader. Is it not possible that the officer concerned, having asked Councillor Jones directly to confirm in his email of the 24th that this was an instruction that had come from the leader, and having had no response to confirm that, is it not a possibility that the officer might have chosen to put in a letter making a formal offer to a buyer a reference to an instruction from the leader in order to protect himself? And that if so doing, perhaps that's a demonstration that there is no record anywhere, and there's good reason why there's no record, why officers have no instruction from the leader.
Yes, in that respect it's possible that the letter at 266 adds nothing to the email at 264, that it's reference to the same solitary conversation. The other point I'd just like to make on this subject is that it doesn't really matter for your purposes what motivation Councillor Cooper had, whether he was acting out of good or bad motives, because the only issue for you is whether Councillor Jones acted appropriately. And we say he didn't, because he did not question the instruction. He did not satisfy himself that there was a good reason. He didn't take any steps to do so. And prima facie, what happened was a non-transparent sale process that Councillor Jones ought not to have facilitated by passing on the instruction without question.
And just finally, Chair, on the bottom of that same letter on page 266, the offer letter to the buyer, it asks for confirmation of acceptance of the offer in writing, and then goes on to say, once I have received your acceptance, I will seek to obtain the relevant consent to dispose, and if approved, instruct our legal services to complete the matter. Do we know what that consent is that would still be required, and who it would be sought from, and is there any evidence that that consent was sought?
No, we've got nothing after this letter to answer those questions.
Mr. Cornwell, just reply.
Just a couple of clarificatory questions. There is reference in the investigating officer's report to several other provisions of the code, and indeed reference to the financial regulations, declarations of interest and so on. But can I take it that your case, the case that is being put now, is simply limited to the points that are set out in your very helpful note? So just the two provisions of the code.
Yes, you can, and indeed you see that in the conclusion to the investigating officer's report, that the final conclusion is that I have determined that the evidence establishes a potential breach of those two provisions only.
The second question is a clarificatory one in relation to the way in which you put your case on paragraph 32D, I think it is, in relation to the impartiality of somebody who works for the authority. Members will often get advice from officers, and they will sometimes not follow that advice for perfectly good reasons. That presumably does not in itself amount to a breach of this provision of the code, does it? So I'm just wondering why you are saying in this case there is a breach of the code, if insofar as it's based on departure from Mr. Lynch's advice and asking him to do something, or implicitly asking him to do something that he's advised against.
Because the crux of this really is the concept of impartiality. Mr. Lynch takes a view, acting impartially, that he has concerns about this and that it's not appropriate for the various reasons he sets out. By, again, being at least complicit in the leader's instruction that he ignore those concerns and sell the property privately, Councillor Jones behaved in a way that was likely to compromise that officer's impartiality, because he had no regard to that officer's concerns. He didn't respond to them. Instead, he instructed the officer to proceed with a process that would result in a sale to one particular individual rather than by way of public competition.
Final point is a practical one. You were asked for various documents and pieces of information in the course of Mr. Tomkinson's questions, and I think there's a further one in Councillor Tro's question. I was just wondering what the timescale for you providing that material is likely to be.
Yes, we'd hope to cover those off within an hour after we adjourn, so the practical thing to do might be for the committee to begin its deliberations, but I'm in your hands in that respect.
Dennis, have you any further submissions at all to make? No? I'll now turn to you, Mr. Tompkins. Independent person, please do make any observations, please. Yes, it appears Mr. Tompkins has some of the papers and correspondence, so we'll have to adjourn for the time being. Thank you.
So I've handed up two. There are more to come, but I thought I'd do them in stages so we're not swamped by them. The first is minutes of an annual meeting on 18th May 2010. This is to answer Mr. Tomkinson's first question, which is when did Councillor Jones become Cabinet Member for Jobs and Economy? The answer is that he was elected or appointed during this meeting, 18th May 2010, and we see that because towards the end of this document, or perhaps halfway through, there's an Appendix A. And on the back of the cover sheet to Appendix A, we see a table showing Cabinet position, member proposed, ward represented. Cabinet position is Cabinet Member for Jobs and Economy, and member proposed is Councillor Jones. So 18th May is the date that he became Cabinet Member for Jobs and Economy. That's the first document. The next is to answer Mr. Tomkinson's second question. That's, did he receive special responsibility payment for his role as a Cabinet Member at the time? So in respect of that, you have Appendix 8, the Members' Allowances Scheme. And if you can turn to paragraph 3.1 in that document, you see there special responsibility allowances may be paid to those members who have significant responsibilities. The regulations prescribe the categories of responsibility for which SRAs may be paid. the Council has determined that SRAs be paid to members holding the following posts, and they include Cabinet Member, which would in turn include the Cabinet Member for Jobs and Economy. So the short answer to that question is yes, he did receive a special responsibility payment for his role as Cabinet Member. The next two documents relate to the third question Mr Tompkinson asked, which is there a job description for the position of Cabinet Member for Jobs and Economy? So the first document you have here is Article 7. These are both extracts from the Council's Constitution at the time. You see that in the top right-hand corner of this document that begins Article 7, the Executive. That sets out the role of the Executive and refers to the leader, which is why we've handed that up as well. And it's perhaps just worth reading the last page, paragraph 7.08, because it relates to another of Mr Tompkinson's questions, which I'll come on to. Paragraph 7.08, responsibility for functions, says all of the authority's executive functions shall vest in the executive leader, and he or she will have the power to determine how these powers are to be discharged, either by himself or he can delegate them to the executive, a committee, individual members or officers. This includes the power of the executive leader to remove or replace members of the executive or to change their delegations. The leader will maintain a list in Part 3 of this Constitution setting out which individual members of the executive, committees of the executive, officers or joint arrangements are responsible for the exercise of particular executive functions. So that's what the Constitution said then about the delegation of certain executive functions. You then have another extract from the Constitution that is headed Leader of the Council. And this goes to the same point about job description. You have there the leader's corporate responsibilities, portfolio responsibilities, and behind that, jobs and economy. So the jobs and economy, Cabinet members' corporate responsibilities. You'll see at page 33 of this document, under portfolio responsibilities, that they include to take responsibility within the Cabinet for, and then there's the heading, the built environment or land, and the fourth bullet point there, land and property management, including acquisition and disposal, in consultation with other Cabinet members where necessary, and where disposal is at less than best value or has implications for the Council's capital programme, in consultation with the Cabinet member for strategic resources, unless responsibility has been delegated to schools. The fourth question that Mr Tompkinson asked was whether Councillor Jones received a briefing on his role as Cabinet member, in particular related to best value and best consideration. I'm afraid we don't know the answer to that. And then the last question was a legal one, which is when we talk about the scheme of delegation and it being not appropriate for Councillor Jones to have overridden the relevant officer's decision, this is the relevant legal framework. So you have here 3 documents. These are the last 3. This is the last point. The first I'd like to take you to is an extract from the Local Government Act 1972, section 123. So you've got 2 extracts from that act. You've got 101 and 123. Taking 123 first, I've referred to this once already. Subsection 1 reads, subject to the following provisions of this section, a principal council may dispose of land held by them in any manner they wish. So there you see the council's power to dispose of land. Subsection 2 is the one that I included in my note and that you've seen already, which is that a council shall not dispose of land for a consideration less than the best that can reasonably be obtained. So that is a power that the council has, a power to dispose of land under section 1231. We then look at section 101, which I've also handed up to you as a separate document. Subsection 1 provides that subject to any express provision contained in this Act, or any Act passed after this Act, a local authority may arrange for the discharge of any of their functions by a committee, subcommittee or officer. So the power in section 1231 is a power to dispose of land. It's also a function of the local authority that the function may arrange to be discharged by an officer. Reading on to subsection 4, any arrangements made by a local authority, this is 101.4, any arrangements made by a local authority or committee under this section for the discharge of any functions by an officer shall not prevent the authority by whom the arrangements are made from exercising those functions. So the authority can delegate the function of property disposal to an officer. Once that function's been delegated, it doesn't prevent the authority from exercising that function, but of course the authority is distinct from its individual members and the leader. And then to complete the picture, we return to the documents in this case. So the third item I've handed up are the minutes of a meeting on the 30th of November 2010. And just to tie this in with what you've already seen, in my note, you'll recall that one of the first documents we referred to, this is paragraph 4 in my note, was Miss Kerry Jones, the Property Review Officer's note of 4th February 2011, when she wrote on behalf of the Director of Strategic Resources to the Director of Legal and Governance Services, attaching the report, the proposed sale by public auction. And in that note, which is page 259, you see the extract there, she wrote, "This matter is forwarded to you in accordance with the authority delegated to the Director of Strategic Resources in the scheme of delegation." And then this is the new document that comes in. "Approved by full council at its meeting on 30 November 2010, minute number 11210E refers." What you have now in front of you that we've just handed up is minutes of the meeting on 30th November 2010 to which Miss Jones referred, an extract from that minute. And if you turn over the page, you can see there minute 11210. That reads, "Senior management restructure, implementation and scheme of delegation to officers. The council at its meeting on 9th November 2010 approved the revised senior management structure of the council for implementation with effect from 12 January 11. And then the last paragraph on that page, "To ensure alignment with the new structure from 1st January, the council received an amended scheme of delegations to officers for inclusion within the constitution." Over the page you see the resolutions. First, that the implementation date for the council's revised senior management structure be brought forward to 1st Jan. Third, that the council receive the revised scheme of delegation to officers as set out in Appendix 1 and approve, and this is perhaps the crucial paragraph, approve the delegation of those functions that are non-executive functions and have not otherwise been delegated by the leader of the council. And then that the revised scheme of delegation to officers be implemented with effect from 1st January and that they be included in Part 4 of the Constitution. So where we've got to then is that you see the council has a power to dispose of land, that it may arrange for that power to be discharged by an officer, and that during this council meeting the council has resolved that certain powers be delegated to officers as set out in the appendix. The appendix is the document you have already, which I took you to and shows towards the back, internal page 26, that there's a delegation of authority to the Director of Strategic Resources over disposal of land and property and disposal of land and premises. So, in short, the Council has delegated the power to the officer. The Council can take that power back, but the leader can't exercise it. The Council's taken a decision to delegate it to the relevant officer. Thank you, Chair. I hope that covers all of the questions, which I think have been helpful.
Thank you, Mr. Dennis. Appreciate that. Thank you very much. Mr. Tompkinson, do you want to come back, please, sir? Carry on, Mr. Tompkinson.
Thank you, Mr. Chair. What I'm going to do now is give you a précis of my full advice to the hearing subcommittee in respect of decisions on whether or not there was a breach of the Code of Conduct by Councillor Jones. I wouldn't at this point propose to read out in full my understanding of what the complaint is. I think that that's fairly well understood and is in the paperwork. Suffice it to say, my understanding, it's regarding the sale or the removal from a public auction of a plot of land at Florence Road. My first consideration is, do I consider this as a valid complaint according to the Council's code? In responding to this, I'd like to comment on the assertions in the correspondence bundle by Mr. Ricker, in which he makes various comments relating to the way in which the allegation was first made, how it was received and subsequently investigated by all those concerned. I do so, and I consider this issue because of the impact of his comments are such that it is possible that somebody might reasonably consider that hearing the complaint is malicious or vexatious. My comment on that is that this matter has been the subject of an internal audit report, a report to and discussion at the audit committee, the subject of an investigating officer's report and consideration by the interim monitoring officer and the monitoring officer. Whilst I'm concerned that this complaint is being considered 7 years after the events took place, I think it's difficult for me to imagine that all of those persons have colluded together to so distort the facts that gave rise to the complaint that I am prevented from taking a clear independent view on the validity of the complaint. I have read all the documentation made available, including that made available by Councillor Jones, and I conclude that the action described appears to potentially infringe the elements of the code that have been referred to, and I therefore consider the complaint was valid. My second consideration was whether I consider the Councillor was subject to the Council's code for this complaint. This allegation has been considered under the 2007 Member Code of Conduct, and I am satisfied that Councillor Jones had acknowledged his responsibilities under the code, which of course was statutory at that time. My next consideration is whether I consider the Councillor was acting as a member when the action complained about was taken. I am now satisfied that Councillor Jones was the Cabinet Member responsible for Jobs and Economy during 2010-2011 municipal year, obviously covering the period of the allegation, and accordingly I consider that the time he was acting as a councillor and indeed was receiving a special responsibility payment for his role as Cabinet Member for Jobs and Economy. I also accept there was a clear job description for his Cabinet role, which specifically included a role to take responsibility within the Cabinet for land and property management, including where a disposal might be at less than best value, only in consultation with the Cabinet Member for Strategic Resources. I conclude, therefore, that Councillor Jones failed to meet the requirements of his role in this instance. My next consideration is, do I consider that there is sufficient evidence that the action complained about took place as described. It has not been made clear to me when the plot of land in Florence Road was declared surplus to requirements, how knowledge of the plan to take this site to auction, outlined in the memorandum of 4th of February 2011, became known to the leader, and whether prior to the 24th of February 2011 there is any evidence that Councillor Jones, in his role as Cabinet Member for Land and Assets, was advised of the proposal for disposal of the land in Florence Road. However, I am clear that on page 264 of the evidence bundle there is an email to Councillor Jones in which the officer refers to an earlier conversation and asks for confirmation that the leader has requested the removal of Florence Road Smethwick from the auction on 10th of March. He then goes on to inform Councillor Jones relating to the price which has been described by Mr Dennis earlier on this afternoon, and I won't proceed to reread that. I am therefore clear that Councillor Jones did supply the name and address of the prospective purchaser to officers on the 24th of February in an email under his name and email address, and there is no further evidence that he took any further action. I'm aware that in an answer to a question by the investigating officer responded that it was not my instruction to remove the property. This definitely reads as the leader's instruction, not mine. If the leader says it's okay, it's okay. I didn't question and assumed everything was in order, which in my view demonstrates a very laissez-faire attitude to the matter and clear breach of his responsibilities under his job description. The draft internal audit report, page 310 of the evidence bundle, says that from our review of the Council's constitution at that time, we can find no reference to any legal authority the leader or Councillor Jones had to countermand the decision made by the Director of Strategic Resources under the scheme of delegation. And I'm now satisfied, following the contribution from Mr Dennis a while ago, that this is quite clear in the Council's minutes. I note that from our review of the records, it was said by the investigating officer that they cannot see the Director of Strategic Resources was informed of this decision. There is no evidence one way or another whether the Director of Strategic Resources was informed of the withdrawal from auction, and the assertion that Councillor Jones and Councillor Cooper all exceeded their authority is, in my view, appropriate assertion. I next consider whether there is sufficient evidence that a breach has occurred. The investigating officer has summarised the response of Councillor Jones to the assertion that he has breached the code in her investigating officer report, and I've also read carefully a letter from Jonas Roy Bloom, Councillor Jones's previous representatives, dated the 8th of November 2017. There is, in my view, no evidence that Councillor Jones was aware of A, the proposed purchaser offer, or any connection between the proposed purchaser and the leader, or any other councillor, or any motivation any party had for preparing a private sale. That is the assertion of Jonas Roy Bloom on the 8th of November. I do not accept that. He received advice of the intended price in the memoranda from the officers. He sent an email containing the name and contact details of the proposed purchaser. But I do accept that he may have had no knowledge of any connection between the leader and the proposed purchaser, but he had no identified motivation to facilitate the transaction other than complying with the leader's wishes, as it breached his job description as Cabinet Member for Jobs and the Economy. By acting merely as a conduit for the leader's request, and in fact having no authority to exercise to require the decision to auction to be overturned, with no insight into the transactions, still less the price, the requirement by Councillor Jones to achieve best value was not engaged in this instance. That is the assertion of his representatives in November. Similarly, they assert that in any event, Councillor Jones relied on the leader, whose request was relayed, and the officers at all times to ensure that best value was achieved. They also assert that Councillor Jones was at all times acting under the belief the sale price and justification for private sale would be resolved later in the process at the due diligence stage, when of course the officers were also involved. I do not accept any of that assertion. Councillor Jones had an overriding responsibility to achieve best consideration for the council, which is clearly spelt out in his job description, and in my view that overrides any other consideration. Jonas, his representatives go on to say that the sale did not proceed with the proposed purchaser, so any attempt to suggest that Councillor Jones's role in a transaction which may have but did not cause loss was a breach of standards is wholly disproportionate. I do not accept that. The proportion is related to the action that he took or failed to take, and I have made it clear previously that I consider that he failed in his responsibilities to try to ensure best consideration for the council. So in summary, I conclude that there is no evidence that Councillor Jones acted on the officer's concern contained in the email of 24th of February 2011 about the sale, and as a result he breached paragraph 3.2d of the code in compromising the impartiality of those who work for or on behalf of the authority. I further conclude that Councillor Jones was negligent in his responsibilities to ensure there was a demonstration of best value considerations, and thereby breached paragraph 5 of the code, which states that a member must not conduct themselves in a manner which could reasonably be regarded as bringing their office or authority into disrepute while in their official capacity. Thank you, Chairman.
Thank you, Mr Tompkinson. I'll now hand you over to Mr Cornwell, the legal advisor, please, for a presentation. Thank you, Mr Cornwell.
Yes, and it now turns to me to give my advice to the panel. At the end of it, I will give Mr Dennis the opportunity to make any observations he has on that advice, and obviously I would have afforded that opportunity to Councillor Jones and his representative had they stayed on at the hearing. I start by briefly advising the committee on what happens, subcommittee on what happens next. After I finish my advice and Mr Dennis has made any observations that he has, the committee will then retire into private session, assuming that there is still time, to deliberate. The decision will be one for the 4 members of the subcommittee to make, and only for them to make. However, they will be assisted in their deliberations by myself as legal advisor and by the independent person. The arrangements made by the Council at paragraph 8.2 then require the Chair to inform the member of the findings as to whether there's been failure to comply with the code. If the allegations are not upheld, then the complaint is dismissed. If they are upheld, it will then fall to the subcommittee to decide what, if any, action to take as a result. If that point is reached, I will be providing further advice for them in that regard. If the allegations are upheld, the member would ordinarily have the opportunity to make representations, obviously if he's chosen to attend, as to what appropriate action, if any, should be taken, and the investigating officer would have an opportunity to make representations in response, with a final brief right of reply for the member. And then the subcommittee would again retire to deliberate in private. Turning now to some general points about the role that you have. First, the Council has the duty to promote and maintain high standards of conduct by its members and co-opted members. That's a requirement of Section 27(1) of the Localism Act 2011. And it must adopt a code of conduct dealing with conduct expected of members when they are acting in that capacity. That's the effect of Section 27(2) of the Localism Act 2011. There were similar provisions in force under the Local Government Act 2000, which at that time there was a model code prescribed on a statutory basis which local authorities were required to adopt, and the Council's code at the time was indeed based on the statutory model code. The Code of Conduct must be consistent with the 7 principles of public life. At the time of the 2007 code, there were 10 principles, but they basically cover the same area. And the Council must make arrangements to do 2 things. Firstly, arrangements under which allegations can be investigated, and secondly, under which decisions on allegations can be made. That's required by Section 28(6) of the Localism Act 2011. We are now at the latter stage, the decision stage. Before it makes a decision on the allegations, the authority must seek the views of an independent person. That's effective Section 28(7)(a) of the 2011 Act, and indeed the subcommittee has now heard Mr Tompkinson's views in the role as independent person. Second general point is that subcommittee is not acting as a court of law, but as with any decision of the Council or its committees or subcommittees, the decision it reaches must comply with general public law obligations. These include A, the decision must be lawful, that is, the subcommittee must not exceed its powers under the 2011 Act or under the Council's constitution or under the arrangements that the Council has adopted. B, the decision must have regard to all relevant considerations, and what is relevant will obviously depend upon the circumstances of the particular case. C, the decision must, in making the decision, the subcommittee must not have regard to irrelevant considerations. Relatedly, D, the decision must be made for a proper purpose. In this instance, the proper purpose is identified by statute, and it's the furtherance of the goal of maintaining high standards of conduct by members and co-opted members. So political or personal advantage would not be a proper purpose for making a decision on a conduct complaint. That would be an improper purpose. Point E, the decision must be a rational one, i.e. it must not be what is known in legal jargon as Wednesbury unreasonable, i.e. so unreasonable that no reasonable decision maker could arrive at that decision. F, the decision must be a procedurally fair one, and that includes being made without actual or apparent bias. My third general point is that the subcommittee members must also comply with their own obligations under the Code, and particularly have the regard to the need to decide matters objectively and to exercise their own judgment. There are essentially 2 tasks that the subcommittee will need to discharge at this stage, and the first of those is to consider what the facts are, and that I will address now. There are various points that I wish to make in relation to making a decision on the facts. The first is that the subcommittee will need to establish what the relevant facts are. It doesn't need to make findings on matters that are irrelevant to the allegations under consideration or to the response to them. Some facts are agreed or not in dispute. In this case, a fairly limited number of facts appear to be in dispute or not agreed. As I say, the subcommittee only needs to decide disputes of fact insofar as they are relevant. Second, the standard of proof to be applied is the civil standard, i.e. the balance of probabilities. That's established by a decision of the Administrative Court in a case called Heesum and Public Services Commissioner for Wales. I.e. a fact is established if it is more probable than not to have occurred. The subcommittee does not need to be sure or to find that something is the case beyond reasonable doubt. It merely needs to be more probable than not. Thirdly, the subcommittee may decide. Subcommittee must decide the case only on the evidence that it has received, either in the hearing bundle or the documents that have been handed up in the course of the hearing, or on the evidence or submissions that it has heard at this hearing or on its earlier hearing on the 1st of December. The committee may, in appropriate circumstances, take into account its general background, knowledge and experience as councillors. That, in my view, is a consequence of it being a task allocated to the council to determine standards complaints. But members should disregard any knowledge that they have which may be about the specific circumstances of the case, which come from any source outside the hearing bundle or the evidence and submissions that you've heard today or on the 1st of December. So the subcommittee members should not take account of information from, for example, the press, radio, TV, blogs, or indeed anything that they have heard at any previous standards hearing. My fourth general point is that it is for the subcommittee to decide what weight to attach to the various evidence it has received. In this case, all of the evidence is in documentary form. There are either contemporaneous documents such as emails and so on, or there are records of interviews or submissions contained in response letter from Councillor Jones's solicitor. As I said, the subcommittee is not a court of law. There is no limit on the admissibility of documentary evidence or hearsay evidence. Indeed, even in a court, it is possible to decide a case solely on the basis of hearsay evidence. But generally, hearsay evidence may carry less weight than direct evidence, and the subcommittee needs to be aware of the potential for misinterpretation or misunderstanding by the reporter or the person who is writing down what has happened. Fifth point, as I said, the factual disputes in this matter appear to be limited. Looking at the investigating officer's report and Councillor Jones's solicitor's response to the draft investigating officer's report and his interview records, the principal area of dispute appears to be whether Councillor Cooper or indeed Councillor Jones had any power to reverse a delegated decision by the director to put the Florence Road plot out to auction. Otherwise, the area of dispute appears to be whether on the facts what Councillor Jones did or didn't do amounted to a failure to comply with various provisions of the code, and that's the second stage, which I'll come to in a moment. I should note that in the course of the submissions that the subcommittee heard, there were various assertions about the way in which the matter has been investigated and various allegations about that. In my submission, my advice to the committee is that those points are essentially irrelevant. The matter for this committee to decide is simply limited to whether or not to the facts of this case and whether or not on those facts Councillor Jones did or did not fail to comply with the Code of Conduct. It will make that decision on the basis of the evidence. The fact that even if it were the case that investigators or whatever had the most malign of motives, ultimately the decision has to be made on the basis of the evidence by this subcommittee. So any opinion that those who either put the matter forward for investigation or those who investigate it might have are neither here nor there. What matters is the evidence, and as I say, in this case, the evidence is primarily documentary in form. It either comes from evidence as to Councillor Jones's own response to questions or responses from his solicitor, or his contemporaneous documentation. This is not a case where the subcommittee is going to have to consider witness evidence and, for example, decide whether a witness may have been motivated by malign motives to say what they said. That's simply not an issue in this case. So that's the that's my advice in relation to the facts. As I said, the second stage that the subcommittee needs to deal with, having identified the facts, it then needs to go on and consider whether there's been a failure to comply with the Code of Conduct. And I turn now briefly to give some advice on that. The subcommittee will need to consider, in relation to each aspect of the allegations, whether Councillor Jones failed to comply with each of the relevant provisions of the Code that are in issue. It is possible for the subcommittee to find that all, or some, or none of the alleged breaches of the Code are proven. Each aspect will need to be considered and separate decisions made on them. Again, as we're making findings of fact, the standard of proof is one of balance of probabilities, so whether on the facts found it is more probable than not that there is a breach of the Code. Thirdly, the subcommittee will also need to decide whether Councillor Jones was acting in his official capacity as a local authority member when he conveyed the instruction to Mr. Lynch. The subcommittee will also need to apply the version of the Code that was in force at the material time, i.e. in February 2011, and that is the 2007 version of the Code, although it is essentially in materially identical terms to the Code as it is currently in force. The failure or otherwise to comply with any of the 10 principles of public life is not in itself a breach of the Code, but it may well be relevant when considering whether there has been a failure to comply with the Code. As has been identified and confirmed by Mr. Dennis, there are now 2 provisions of the Code that the subcommittee is being invited by the investigating officer to find were breached. Paragraph 3.2d, which relates to a member doing anything that might compromises or is likely to compromise the impartiality of those who work for the authority. And paragraph 5, which is concerned with bringing or being likely to bring into disrepute the office of local authority member or the authority. And in regard to the latter provision, there are 2 limbs to that. One, bringing the office of councillor into disrepute, and secondly, bringing the authority into disrepute. And the investigating officer's case appears to be that both limbs are in play. So to conclude, that's my advice in relation to what the subcommittee will need to go on and do in reaching its decision. As I said, the decision is one for the 4 members of the committee. You have heard my advice. You have also heard the views of the independent person. Those views must be taken into account, but they are not binding on the subcommittee. The subcommittee must reach its own view, its own independent judgment based on the evidence that it has read and heard, and the submissions it has heard and read. I think, unless there's anything else that the subcommittee wants to ask me, that's my advice. Just turn to Mr. Dennis, see if he's got any observations, anything that I've missed or got wrong.
No, I don't have anything.
There's no observations, Mr. Dennis? No, thank you, sir. Was there any points of clarification from the panel at all? No? Thank you. That only leaves us now to adjourn and deliberate on the case. Thank you. decision has been taken. The subcommittee at today's hearing have reached a decision, and I'll now hand you over to Mr Cornwell to make a statement on that direction. Thank you.
The subcommittee have asked me to read out a short summary of the decision. The full reasons will be set out in due course in the decision notice, but given the hour, this is a brief summary of the position. As I said, this is a decision of the four members of the subcommittee. The subcommittee members have reached a decision on whether Councillor Jones failed to comply with the Code of Conduct. In doing so, the subcommittee has considered carefully all the documentary evidence in the hearing bundle and that handed up at the hearing, and the submissions made by Councillor Jones before he left the hearing and by counsel for the investigating officer, Mr Dennis. The subcommittee took into account the advice of its legal advisor and the views of the independent person. The unanimous decision of the subcommittee is that Councillor Jones failed to comply with both paragraphs 3.2d and paragraph 5 of the 2007 Code of Conduct in relation to the removal of the Florence Road plot from an auction. The subcommittee will set out its reasons in full in its decision notice, which will be prepared in due course. The next thing that would happen under the procedure is that the member would have the opportunity to make submissions in relation to what actions, if any, the subcommittee should take. The committee have discussed this, and in view of the fact that Councillor Jones attended the hearing and then chose to leave, despite being warned that the proceedings may continue in his absence, the subcommittee is minded to move to at least hear submissions and advice in relation to sanctions. So if Mr Dennis has any submissions in relation to sanction, the committee would welcome them.
Yes, thank you. Can I refer the committee then to the relevant part of the arrangements, which is in the main bundle? It's section 9, which is page 24. Yes, certainly. Page 24. So as I say, it's section 9. What action can the subcommittee of the Standards Committee take where a member has failed to comply with the Member Code of Conduct, and the possibilities are there set out. The Council has delegated to the Standards Committee such of its powers to take action in respect of individual members as may be necessary to promote and maintain high standards of conduct. Accordingly, a subcommittee on behalf of the Standards Committee will publish the breach of the Code of Conduct and the sanction imposed on the member's profile on the Council's website for a period to be determined by the subcommittee, which is to be no less than the time required for compliance with any sanction. Now, pausing there, the first issue for you to consider, it seems to us, will be the period of time for which the breach and the sanction imposed is displayed on the Council's website. In our submission, an appropriate period of time would be for the remainder of Councillor Jones' current term, i.e. the term for which he has been elected, which on our preliminary investigations during the adjournment takes us up to May 2020, but that is something the committee would need to check. The reason for that is that it would ensure that the committee's findings are in the public domain and available to the electorate when they consider him for re-election, if indeed he does stand for re-election. Returning to the arrangements and reading again to the words there, if a member fails to comply with a sanction in the timescale set, the information will remain on the profile until compliance is achieved. The subcommittee will also report its findings to Council for information. And then the Standards Committee may first recommend to the member's group leader or in the case of ungrouped members, recommend to council or to committees that he or she be removed from any or all committees or subcommittees of the council. Now again, our investigations, or those that we've been able to carry out in the short time we've had, suggest that Councillor Jones is only the member of one committee, which is the Economy, Skills, Transport and Environment Scrutiny Board. We suggest that he be suspended from that board pending training, which is another point I'll come on to. It's another provision in the arrangements that you may instruct the monitoring officer to arrange training. As I'll come on to in a moment, we think that would be appropriate. We also think it would be appropriate for you to recommend that he be suspended from membership of that board, which is of course a scrutiny board, until he has had that training. 9.2 is that you recommend to the leader of the council that the member be removed from the cabinet or removed from particular portfolio responsibilities. As far as we're aware, that it doesn't apply to Councillor Jones because he doesn't have any such responsibilities. Third, that you may instruct the monitoring officer to arrange training for the member. That seems to us to be entirely appropriate, not least because we had not been able during the hearing to establish when he had received training, and because of course he's now been found to have failed to comply with his obligations under the code. We suggest that it would therefore be appropriate for you to instruct the monitoring officer to arrange training for him, both on the contents of the code generally and your findings, so with the benefit of your reasons. 9.4 is that you may recommend to council to remove from all outside appointments to which he or she has been appointed or nominated by the authority. Again, as far as we're aware, there are no relevant appointments in that category. 9.5, that you may withdraw facilities provided to the member by the council, such as a computer, website and or email and internet access. We don't say that is necessary here. The nature of the allegations doesn't suggest that he needs to have access to those facilities withdrawn, or the nature of the breaches, I should say. 9.6, that you may exclude the member from the council's offices or other premises, with the exception of meeting rooms as necessary for attending council committee and subcommittee meetings. Again, we don't say that's necessary here because of the nature of the breaches. And then over the page, the concluding two paragraphs on your powers just make clear that you may take such steps as appropriate, reasonable and proportionate to the particular conduct that amounted to the breach, and that you have no power to suspend or disqualify the member or to withdraw members or special responsibility allowances. So to sum up, in our submission it would be appropriate for the breach to be published on the council's website for the remainder of Councillor Jones' current term as a member, for this committee to recommend to the group leader that he be removed from the Economy, Skills, Transport and Environment Scrutiny Board pending training, and that training be organised on both the contents of the code and this committee's findings.
Thank you for those mentions, Mr. Dennis. I do appreciate it. I'll hand you back now to Mr. Tompkinson, please. Thank you.
Thank you, Mr. Chairman. My role at this moment in time is to give the subcommittee some advice on the nature of the sanction that it should introduce. I think that the decision on the actual sanction that you wish to impose is a matter for the subcommittee alone. I'm going to restrict my advice to you in terms of what I consider to be aggravating factors or mitigating factors that would, after due deliberation, would lead you to conclude as to the magnitude of the breach that has taken place, whether it is a minor breach or whether it's a major breach, and various gradations within that. So as far as I'm concerned, that the aggravating factors are, in summary, as follows. Firstly, there is clear evidence that Councillor Jones was aware of his responsibilities and acknowledged such to abide by the code in his role as a councillor, and that indeed at the time he was actually acting as a councillor. Secondly, that he held a cabinet post within the authority, and obviously at that point he had a responsibility to act in a manner that befits a cabinet member of a council such as Sandwell. Thirdly, that at the time the events took place, he was aware from the correspondence that he had through email with the officer that he knew the price that the land at Florence Road was being offered for in terms of both the guide price and reserve price. And he had no way of knowing at that moment, because he didn't take the trouble to check, whether or not the private treaty was going to be at the same price level or some other price level. And he did nothing that is evidence to investigate whether that would be the case or otherwise. And so as a result of that, he was endangering the council receiving best consideration for the disposal of that land. Fourthly, he failed to carry out his responsibilities as described in his job description, which have now been clearly proven he had received directly from the council because of his appointment as the cabinet member for jobs and economy, and for which he was receiving a significant special responsibility payment, and that amounts to effectively a dereliction of his responsibilities. There are, however, a number, or one or two anyway, mitigating factors. The first of which is that this took place some considerable time ago, and one anticipates that it may well be that if these set of events took place now, there would be systems and procedures in place in the council to prevent this happening again, and that Councillor Jones might not follow through the same chain of events. Secondly, that there is an assertion by Councillor Jones that he was merely following instructions from the late leader of the council. We have no other evidence to verify whether that is indeed the case, but it is, in Councillor Jones's mind, I would assume anyway, a mitigating factor that he would want to put forward. Thirdly, I do accept that he may have had no knowledge whatsoever of who the purchaser was, although obviously he knew the name and address, but more particularly of any connection between the proposed purchaser and any other member of the council. And so as a result of that, his actions did not constitute him seeking to take any advantage for himself or any other person. Thank you, Mr. Chairman.
Mr. Conway.
Yes, I'll just now give the subcommittee some brief advice, legal advice in relation to sanction. The Localism Act 2011 says, doesn't say very much about sanction, but it says this at section 2811. If a relevant authority finds that a person, a member or co-opted member of the authority has failed to comply with its code of conduct, whether or not the finding is made following an investigation under arrangements put in place under subsection 6, it may have regard to the failure in deciding whether to take action in relation to the member or co-opted member, and what action to take. So the first point I make is that the first question that the subcommittee will need to address is whether to take any action at all. That's clear from the statutory provisions governing this regime. There may be cases where a council considers that it's appropriate that merely the finding of failure to comply with the code and the publicising of that finding is sufficient action. If the subcommittee concludes that that is not appropriate in this case, the next step would indeed be to go on to consider what further action might be taken. Mr. Dennis has already taken you to the relevant section of the Council's arrangements, section 9. That sets out a non-exhaustive list of potential sanctions, potential actions that could be taken. Key points to note are that there is no power for this committee, or indeed the Council, to either suspend Councillor Jones or to exclude him from office or to withdraw any members or special responsibility allowance. In considering what sanction to impose, the subcommittee will need to take such steps as are appropriate, reasonable and proportionate to the particular conduct that amounts to the breach of the Code of Conduct. So you will need to bear in mind your findings as to what Councillor Jones did or did not do, and you will need to have regard to which particular provisions of the Code you have found to be breached. In this case, the two provisions are paragraphs 3.2b and 5. You will then need to consider which of the list of potential sanctions are relevant in this case. Some, it would appear on the face, are simply not relevant, others may well be. And balancing that up, taking account both of factors that you consider are potentially aggravating and also factors that are potentially mitigating, you will need to decide what is proportionate and appropriate in this case. Two particular points I would mention in relation to what you may want to take account of are one that Mr. Tompkinson has already referred to, and that is the passage of time. It's now nearly 7 years since the breach took place, and that may well be a factor that you consider to be relevant as to the risk of further offending. The other factor I want to highlight is insight or lack of it on the part of Councillor Jones. It is often the case that bodies that are imposing sanctions for conduct breaches, not just in this context but in professional context, will need to consider whether the defendant has shown insight into the behaviour that has led to the misconduct, and that can be a relevant factor, both potentially mitigating and indeed aggravating if there is an absence of insight. Once you have, you will, as I said in my main advice earlier on, you'll need to apply normal principles of public law. You'll need to make a rational decision, taking account of relevant considerations. All those kinds of consideration that I have highlighted previously will need to be applied by you in reaching your decision. Unless the subcommittee have any questions on my advice, I'll just ask if Mr. Dennis has any observations on what I've said.
No, I have nothing to add.
And obviously, as I said earlier, I would offer that opportunity to comment on my advice to Councillor Jones had he remained at the hearing.
Beg your pardon. The subcommittee will now adjourn and deliberate in private on the sanctions regarding to section 9, what we decide, and come back later. Thank you. Thank you, everyone. We have concluded and deliberated on what sanctions to impose. And I'll now hand you over to Mr. Cornwell, our legal advisor, to make a statement on that issue. Thank you.
Thank you. Once again, this is the decision of the 4 members of the subcommittee, having received advice from myself and from the independent person, but it is a decision of the 4 members which they've asked me to read out. Again, this is a summary of their the sanctions, that their decision in relation to sanctions, and a full reasons will be set out in the decision notice in due course. 1. The subcommittee has decided that it is appropriate to take action in relation to Councillor Jones's failure to comply with the Code of Conduct. 2. The subcommittee's decision notice be published on Councillor Jones's member profile for the remainder of his term of office, or if later, until he complies with the sanctions set out below. 3. The subcommittee recommends that Councillor Jones be suspended from membership of the Economy, Skills, Transport and Environment Scrutiny Board and not be appointed to any further committee until he has carried out training to the satisfaction of the monitoring officer as set out below. 4. The training is to be bespoke training to ensure that Councillor Jones understands appropriate competencies, responsibilities and behaviours in carrying out his responsibilities as a member of committees. Such training to be at Councillor Jones's own expense. I think that concludes matters.
Thank you, Mr. Will. That concludes the business of today's hearing. Thank you. And I want to put on record the council officers who attended today. Thank you. Thank you very much. Oh.
Right. Okay, if you can, yeah, testing. It sounds all right at this end. Chantel, how's it sound over there?
Sounds pretty fine. Can you give us sound and visual, please? Confirm, please. Can you confirm that we have sound, please? Testing. 1, 2, 3. Do we have sound? how is the sound? Can you please hear anything? How is this sound? Audio okay?
Testing, testing.
Is any sound coming through? Please confirm.
Testing for sound and video.